Court does call the case of the people of the state of Michigan versus Jeremy Schultz.
Thank you and good morning, Your Honor. Assistant Public Defender Constable based on behalf of Mr. Jeremy Schultz, who is present from the Wayne County Jail by Zoom. Mr. Schultz, could you state your full name for the record?
Jeremy Schultz.
Your Honor, we're going to be requesting a brief adjournment. My client, I believe, is due to get out on the 7th. Able to contact him. So
He's what?
I believe he's due to get out on the 7th. Is that correct, Mr. Schultz?
Yes.
You're getting out on the 7th.
Yes.
So do you want you don't want the 10th, you want the 17th?
That would work better, Your Honor, please.
Without objection, probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
We'll be in touch, Mr. Schultz.
All right.
Court does call the case of the people versus Hector Gonzalez. Did I wake you? No, go ahead.
Not yet. Your Honor, not yet. Mr. Gonzalez, come forward. Stand here. Tell the judge your name. Michael Vincent on behalf of Mr. Gonzalez.
Hector Gonzalez, Your Honor.
Good to see you, Mr. Benson. I haven't seen you for a while.
Lucky you.
Yes,
May I approach with the prosecutor?
do it. Yes. Reflect, we've had a bench conference.
Your Honor, we're going to need at least a week adjournment because discovery is incomplete.
All right. Is there somebody here with you or did they send you on your own?
No,
No,
they left.
they sent you on your own?
Yep. Amanda took the day off.
Okay, there's supposed to be a green form filled out.
I'll fill it out.
Could somebody help Mr. Benson? Thank you. All right, probable cause conference in this matter will be adjourned to July 17th, 2025, 9 a.m. Bond on this case will continue. Mr. Gonzalez, I was informed, and I think you have been informed that there's a violation of probation warrant. And that has no bond. So on it, Mr. Benson, did you want to, you don't represent him on that?
No, I don't, but I've talked. And Your Honor, on this present case, could he have at least $100 cash bond so he earns some time?
People don't have objection to the real cash bond, Your Honor.
I'll set his bond in this, on the case that I just called as a 1,010% bond. All right,
That'll be for time.
but on the warrant was issued by Judge Slay. There is no bond, it's violation of probation warrant. I'm going to remand you to the Washington County
I'll
Jail.
try to get you a range.
This time as you can be heard in that
I
court.
gotta go with this.
All right, he's remanded. Court does call the case of, are they there? Court calls the case of the people versus Robert Middleton. Morning.
Like the talking about hearing gift and on behalf of Robert Middleton.
Your name, sir?
Robert Middleton.
All right. What are we doing?
We would like to set this matter for a preliminary examination.
All right. All discovery is complete.
Yes, to our knowledge.
People have their witnesses available on the 15th. All right. Preliminary examination will be set in person July 15th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you, Your Honor.
Court calls the case of the people versus Virgil Dunlap.
Andrew Children, Second County.
That's Mr. Brutus.
Virgil Dunlap. We have Miss Yagi listed, so.
Can't look it up.
Pardon?
We can click it off.
Okay,
I believe we're looking for Mr. Drukas right now, Your Honor.
That's it. Court calls case of People versus Ibrahima, is it Dikite?
Good morning, Your Honor. And Assistant Public Defender, Tanazi Terry, I can move on behalf of Mr. Ibrahim Diakite. Mr. Diakite, state your name for the record when you reach it, please.
Judge, good morning. I was appointed on his home invasion third matter on 23 F10699. Last,
10699.
yeah, last night about 7 o'clock.
Informed me that, I usually has an interpreter.
You understand? No, you understand English, correct? Is that a yes? Is that a yes?
Yes.
Okay,
So he does not need an interpreter.
I don't believe.
Do you need an interpreter?
No.
No, Your Honor.
All right. What are we doing on these?
Your Honor, we're asking for an adjournment.
Yes, Your Honor.
All three matters.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond in these matters will continue.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Court does call the case of the People versus Tanya Hall.
Good morning, Your Honor. Calvin Hawthorne for the people.
Morning, Your Honor. Just go on back to Ms. Hall. Judge, is Ms. Hall here? Judge, as you know, Ms. Hall is an elderly lady. She lives at the Delana Center. I have no phone. I have no email. I would ask the court, you being the compassionate judge you are, if you would adjourn this 1 week. I will go.
We received a communication from Community Corrections indicating that your client presumably left a voicemail, or a woman, that Ms. Hall was in the hospital. She then received an email stating that she was discharged from the hospital. So I don't know why she's not here.
Judge, you know, I believe you know her circumstances. Would you give me 1 week? I will go to Delana Center and inform her. I have no other means of communication.
Bench warrant will issue for defendant's failure to appear. Bond is setting him on a $10,000 cash surety. I won't have the warrant issue until the 8th. Give you time to try to find her.
Thank you, Judge. Appreciate it. Have a good work.
I will be. Court does call the case of the People versus Anthony Turner.
Your children's screen numbers for the people.
Honor, the person they had waiting was not Mr. Turner. I do believe they're going to go back and get Mr. Turner now. I don't know who the individual was standing there, but Stephanie Cannon on behalf of Mr. Turner. Okay. Oh, where are you? Your Honor, we are asking for an adjournment. He has been screened for mental health court. We're just waiting for the evaluation. Hopefully with that, the prosecutor and I can come to a resolution. We are waiting for it. They have to give it to us.
Will the 17th be enough time? You need one more week.
Your Honor, they indicated that they were going to try to get it to me today. When I checked, it was not there. So that should be fine.
Give you two alternatives. That should be fine.
Whichever
July
one,
17th, July 17th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Court calls case of the People versus Mary Collins.
Christina Berry, requesting petition practice for rule 8.120 under the supervision of the exact.
Practice granted.
Thank you, Your Honor. Christina Berry.
Tyler Burrell on behalf of Mary Collins. Ms. Collins, please say your name.
I'm Mary Collins.
Just so you understand, is a date and time set for probable cause conference. I have been speaking with EPA Ward on this morning about trying to come to some sort of resolution. We're asking for a 1 month adjournment here to let Ms. Collins.
1 month. Why do you need one month?
Which is basically to Ms. Collins basically needs to earn an offer at this point. And so we're giving her some time to provide that material and provide that proof. We can do less if the court.
I don't, well, you're gonna do whatever I say, but I'm just trying to figure out why you may need it.
Your Honor, I talked to Mr. Bedell about providing mitigation information. I was thinking that could happen in circuit court or down here, but we have to keep things moving, so I defer to the court.
And if the court would like to see it sooner, we can do that as well.
July 24, 2025, 9 a.m. bond continued.
Thank you, Judge. Welcome to you in the hallway.
Thank you.
Thank you, Judge.
Court calls the case of the people versus Sean Newcomb.
Maybe Richmond looking for the people? Like about appearing with and on behalf of Sean Newcomb.
Please state your name for the record.
Sean Newcomb.
Has the court received the evaluations from the forensic?
I have.
We have nothing further to present in this matter. Set an order finding him competent.
Based upon a review of that report and the evidence submitted, the court would find that the defendant is at this time competent to stand trial, which specifically find that the defendant can understand the nature and objects of the proceedings against him and rationally assist in his defense. Therefore, the defendant is deemed competent. Do I have an order?
Yes, we've sent an order finding him competent
When did you send the order?
earlier today,
Oh, this morning in the middle of this docket.
before the
So right now, we really don't have an order.
before the doc.
I have to have my staff pull it off
Yes, Your Honor.
and stop everything to have it happen. Do you?
Oh, there you go.
What do you mean, there you go? You sent it this morning. Really? 9:12, even after the docket time start. Did Brown tell you to do that? He did, didn't
No, Your Honor, I did it.
he? You don't have to fall on a sword for him. All right, I signed the order that came in late.
Thank
All
you,
right.
Your Honor. We would like to set this matter for PCC.
Set a probable cause conference with 2 weeks be enough time for it. Set a probable cause conference July 17th, 2024, 9 a.m. Bond will continue. Court calls case of the people versus Jessica Hafner.
Morning, Judge Calbrell, on behalf of Ms. Hafner. He's approaching the podium. Ms. Hafner, please state your name for the record.
Jessica Hafner.
Thank you.
And Your Honor, I was just very recently appointed on this matter. We are asking for a brief adjournment at this time.
July 17th, 2025, 9 a.m. Bond continue.
Thank you. Judge, if the defense may be heard as to bond.
She's out. 17th.
Thank you, Judge. So Ms. Hafner currently has a no contact order with her children. 2 of her children have a bad hereditary condition that requires constant and fairly advanced medical treatment. There could be a hospitalization or I believe you said a surgery sort of at any given time. Name of the disease was too complicated and long for me to even write down here, but we are asking for a modification to the no contact order to allow supervised contact for the purposes of medical treatment only.
Response from the people.
We would ask that the bond remain set where it is until we can have an exam or resolve the case.
I mean, is CPS involved?
Yes, Your Honor.
Has CPS?
I'm looking, a referral was complete at the time of this investigation.
Right.
They're pacing it.
How many children are involved in this one?
Elijah appears to be the victim.
There's only one child named in the complaint, Judge, yes.
As far as the victim. I mean, I'm concerned, Your Honor, when the police came to investigate, the defendant took a long time to answer the door. She said that he was sleeping and they needed to check the welfare of Elijah. He was in his bed covered with a blanket, but not sleeping. They immediately observed blood coming from his face as well as tears from his eyes and blood on the chin. So we would ask that bond continue. I don't think it's appropriate for her to contact with any patient.
And if, for what it's worth, Your Honor, Elijah is not one of the children that has the condition.
Well, but I'm not, you know what, I tell you, what, I'm not gonna change this, and I'm not gonna change this on the fly, certainly. If you believe that it should be changed, file a written motion, I'll hear it, but I'm not gonna do that. Motion for bond reductions tonight at this time, or bond modification is tonight.
Understood. Thank you, Judge.
Court calls case of the people versus Thomas Vash.
Morning again, Your Honor. Constable Bill Basie on behalf of Mr. Thomas Vasher, who's approaching the podium to my right. Mr. Vasher, can you state your full name for the record, please?
Thomas Vasher.
All right, what are we doing?
Are you sure? Yeah.
Really?
Sorry. Your Honor, today's the date and time set for probable cause conference. At this time, my client has been offered by the APA, and he wishes to avail himself of that offer, Your Honor.
Your Honor, the plea offer extended by the people was that Mr. Dashir was made to charge count 2, the people dismissed count 1.
That's correct reflection, Your Honor.
Did you fill out a plea form? Even though it's the stated count, I've got to have the plea form.
Okay, I was under the impression that the plea form didn't need to be filled because it was already on there, but we can fill it out, Your Honor.
That, although it's a stated count, because the change is what the defendant has to acknowledge, you need to fill out a plea form. I don't care whether it's stated.
Understood.
I'll pass it. Thank you. Court calls case people versus Bianca Row.
People.
Hi. He went out.
Good morning. What's your name?
Bianca Row.
Where's Mr. Burdell?
Went out.
Seriously.
Kyle Burdell on behalf of Ms. Rowell. My apologies, Judge. Ms. Rowell, have you stated your name? Okay. So, Your Honor, today is the date and time set for probable cause conference. I have given quite a bit of mitigation documents to the prosecutor. It's my understanding they need a little more time to review that. And so we are asking for a brief adjournment.
July 17th, 2025, 9 a.m.
Thank you, Judge. We'll talk out in the hallway with you.
Case of the cases of the people versus Todd Rabberg.
And for that is for the people?
Assistant Public Defender Jay Ballinger on all cases not ending in 0891, Your Honor.
Kyle Burdell in the only case ending in 0891. Have you got the phone for this one, phone number? Thank you, sir. Thank you, sir.
Apparently, I didn't even know that. Can you state your name for the record, sir?
Todd Rabberg.
All right, what are we doing?
Your Honor, yesterday I submitted an order for the court, a stipulated order for the court. My understanding is that all other orders are signed for him in an effort for him to go to treatment. My belief is that these are the only 2 cases that I submitted to the court, the stipulated order for that he does not have an order signed in order for him to go to treatment. We were asking.
Sign the order.
I'm sorry?
I've signed the order.
Okay, we were just asking for a 3-week adjournment in an effort to get him into treatment and track his progress.
Mr. Burdell.
Judge, the defense moves into would join that motion on my case as well.
Probable cause conference, July 24, 2025, 9 a.m. bond will.
Thank you, Your Honor.
Yeah. Court does call the case of the people versus Taylor Adams.
We're ready in this matter, Your Honor. Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Taylor Adams. Mr. Adams, could you please state your name for the record?
Taylor Adams.
Thank you. Your Honor, today is the date and time set for a probable cause conference. We have made great strides in working out a plea agreement. However, there's still some further information that we'd like to provide to the prosecution. So we'd ask for a 1 or 2 week adjournment so that can take place.
Probable cause conference without objection, July 17, 2025, 9 a.m. Bound.
Thank you very much.
Thank you, sir.
Thank you.
July 7th.
Court calls case of the people versus Brooke Bailey.
Assistant Public Defender Jay Bell on behalf of Miss Bailey. Miss Bailey, can you please state your name for the record?
Brooke Bailey.
Your Honor,
She's waiving.
yes, she is.
Ma'am, you're waiving your right to a preliminary examination.
Say yes.
Yeah, yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right. Preliminary examination having been waived, defendant found over to circuit court on a single count.
We acknowledge receipt of information, wait formal reading, stand mute at this time, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
Perfect.
At 1:30 with Judge.
July 22nd, 2025, 1:30 before Judge Conte. Bond continued.
Thank you, Your Honor.
Thank you.
Court calls case people versus Abdul Ramen Adal. Adaliyah. I messed it up again. But we'll get it.
And Alex Warren Green on behalf of Mr. Al Dayef. Could you please state your name for the record?
Abdul Ramen Adal.
Exactly what I said.
Your Honor, today's date and time for probable cause conference. At this time, we are requesting an adjournment to complete media discovery.
To do what?
To complete media discovery, Your Honor.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
One second, the video.
Court does call case of the people versus Quincy Jones.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Jones on case ending 0697.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Jones in case 21574.
Okay, in both cases, I have an indication that there are plea agreement form that he is going to be guilty to an added count 2 of use of a controlled substance in both matters, so 1 year offense upon a successful plea with those charges count 1 in each case.
That is correct, Your Honor.
That is correct, Your Honor. I have gone over his rights with him.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Help me, God, yeah.
State your name.
Quincy Jones.
All right. Sir, it is this court's understanding that you're going to be pleading to 2 counts of use of a controlled substance.
Yes.
All right. Is that correct?
Yes, Your Honor.
Those are misdemeanors, punishable by up to 1 year incarceration at $2,000 fine plus court costs. You understand that?
I understand.
You understand also in one of the cases, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of use of a controlled substance contained in case ending in 0697, how do you plead?
Guilty.
To that same charge contained in case ending in 0574, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
You have any question regarding any of those rights?
No, I read them thoroughly.
Pardon?
I read them thoroughly.
You understand them?
Yes, I do.
All right, so you have no questions.
No question.
Is anybody? I think we look at paragraph 5, excuse me. Copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes,
You understand you're giving up your right to appeal of right?
yes.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
He's asking if everyone's made you any promises beyond.
No.
Anybody threaten you or coerce you in any way?
No, they haven't.
You're doing this voluntarily
Yes, I am.
of your own free will,
Yes, I am.
and because you believe that you are indeed guilty of these offenses?
Yes, I am guilty of these offenses.
Okay. Starting with the case in the 14A2 jurisdiction, City of Ypsilanti, on March 14, 2025, the location of Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes, I had.
Did you know what you were using was cocaine?
Yes, I did.
And on the other matter, on the date of February 9th, 2021, at the location of 2201 Hogback Road, that being the Washtenaw County Jail, did you have cocaine? Did you have fentanyl in your possession?
Yes,
Had you used it?
yes,
Did you know what you were using was fentanyl?
yes, I did.
All right. Sir, I need you to also understand that if I accept your plea and between the time of sentencing and the time of, between this plea and the time of sentencing, if you commit misconduct as defined by the court rule, that any agreement or sentence evaluation or case evaluation would, the court is not bound by that. You understand that?
Yes, sir.
You also understand that you could not then set aside your plea.
Okay.
You understand that, sir? All right. Is counsel aware of any other promises, threats, or inducements that have led to these pleas?
No, Your Honor.
No, Judge.
And has the court complied with the court rule, and would it be proper to accept the defendant's plea?
People satisfied on both matters.
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's pleas of guilty to count 2 in each of the cases. Count 1 is dismissed. In the 14A2 matter, pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in that case will be July 9, 2025, 10 a.m. That is before Judge Barr. Bond on that matter will continue.
Your Honor, may I address Bob?
I knew it. I was trying to sneak it in before you said something, Rushy. In the other matter, let me just finish up the other matter. In the other case, defendant is count, if I didn't say so. No, count 1 is dismissed, except the plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
July 30th, 2025 at 12 p.m.
no. I have a sentencing. 9th, he's in custody. That's the date we'll give. July 9th, 2025. Time? 9 a.m. So you can come here and then get over to Judge Barr, and that's before me. As to bond.
Your Honor, I'm asking that Your Honor consider reducing this down to a personal bond. Bond was revoked because Mr. Jones failed to come to community corrections. I know Your Honor is very well aware of the last time. Exactly. But Your Honor, but Your Honor,
it wasn't just he didn't go to community corrections. Isn't that correct?
that was, Your Honor, something may have happened prior to my appointment, but when I was appointed on the matter, he hadn't came to community corrections.
Yeah, he probably came down off all those drugs. Go ahead.
Well, Your Honor, that's new information to me. But at this time, he has accepted responsibilities in this matter. He will appear at his sentencing date. I've had a conversation with him. He understands that he does need to turn himself into community corrections and he does need to test. So I'm asking Your Honor, consider reducing this down to a personal bond.
Your Honor, I would just add that I have been in touch with the social worker assisting him from Avalon Housing, and they are prepared to help him engage to whatever extent is necessary.
Any response from the people?
Yes, Your Honor, and happy to fill in Ms. Rushing as well. Prior to her appointment on that other matter, Mr. Jones had appeared in court extremely under the influence of multiple drugs that he admitted to. I think it was cocaine and THC at the time. Not sure what else may have been in his system. The concern of the people added to that is that prior to that, Eric's in court under the influence, Mr. Jones had actually been in treatment and been hospitalized. So I'm very concerned that he's just not able to comply with the court's orders of staying for using drugs. And it was then that his failure to report for testing after that occurred after he had still been allowed to be released on PR. I would prefer that he at least remain in custody until his sentencing on July 9th.
All right, until I have an additional evaluation, I'm going to deny the request for any type of bond reduction. Defendant bond will continue in each court.
Thank you, Your Honor.
Thank you.
Happy holiday, Judge.
Yes, and to you.
Have a great day.
Court calls the case, People versus Elton Bell. Oh, boy.
Good morning, Judge. Kerma Dadush on behalf of Mr. Bell, not with. Mr. Bell is 65 and is not able to drive. He had a ride who was supposed to bring him here. He told me he's
If
fine.
you say he's coming on a bus, I'm coming up.
He's not, I don't even think he can navigate a bus. Not because of, he's just, I even tried to get him on Zoom. I don't think he can navigate that either. I would have gone down that route knowing he does not have a ride, a consistent ride. In any case, Your Honor, can we please pass on this?
You want me to pass it?
Yes, please. I'm
Okay.
trying to find
Then what's
another
going to happen?
when he
Between-
comes. Oh, he's finding another ride. He's appeared every time before, Your Honor. I believe it's his first time not appearing. I can get him to send photos of a bus.
Of what? You know what?
If that would
You know
be
what?
helpful.
I'll pass it.
Thank you, Your Honor. Thank you, Your Honor.
Wow. Court calls the case, People versus Ramen Muhammad.
Andrew Childers, agreeing on behalf of the people.
Kyle Burdell on behalf of Mr. Muhammad. Mr. Muhammad, please state your name.
Rahman Muhammad.
And Your Honor, may we approach briefly? Very briefly.
Yes.
Thank you, Judge.
Record should reflect that we had a bench conference in this case. They're requesting an adjournment.
Yes, Judge.
Probable cause conference, July 17th, 2025, 9 a.m. Bond continues.
All right, we'll be in touch with her, and then we'll come to the judge.
Court calls case, People versus April Black.
Your Honor, Alexis Plumey on behalf of Ms. Black. And Ms. Black, could you just state your full name? April Black. And Your Honor, today is the date and time for probable cause conference. I do have a green sheet filled out. We are just asking for an adjournment for plea negotiation purposes, if we could go about 2 weeks. And then, Your Honor, I would like to address a couple conditions of bond.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Yes, that's the bond.
So currently, Ms. Black is on a GPS tracking tether. And there is also an order that she not go to her mother's house, but not an order that she not speak to her mother. Ms. Black lives about a block away from her mom. It's my understanding there was an incident immediately preceding this one that is still being investigated, where Miss Black and her mother would be the alleged victims. From what I understand, Miss Black was ordered not to go back to her mother's place because another person involved may live in the area. However, Miss Black has 4 children. She's still living a block away from her mother's house, and it is just inconvenient that she can't go over there and drop her kids off because her mom does help with childcare. And additionally, I feel that condition doesn't really relate to the charges in this case. So if you'd consider lifting that no-go to and removing her GPS tracking tether. And I don't believe there's any suggestion that Miss Black is a flight risk.
Response? I would ask at least for this, at this point, the remain is currently set. When the police had contact with Miss Black, it wasn't a call regarding potential FA, but she was highly intoxicated, really aggressive with police, ended up doing police car, was combative. I'm just concerned, whatever the heck is going on at that 407 address. I would hate for there to be any sort of bringing up whatever dispute led to the initial police contact that would cause Miss Black to have a negative impact on this case.
Motion for modification of bond, change in any conditions is denied. Bond will continue with its conditions.
Your Honor, if I could just clarify about the tether, I believe the tether is just tracking her. It's not an exclusion zone.
It's a location tracking tether.
Yes, so I'm not sure what purpose that.
So you want me to redo the ruling I just gave? Is that what you're asking? How many times have you been before me? Yeah.
Few.
How many times have I ever done that when I finally ruled?
Understood, Your Honor.
Never.
Understood.
So I don't know why you think I'd start today. So are we done?
Yep, we're done.
Okay, thank
you.
Court calls the case People versus Raymond Bowman.
Constable Bates on behalf of Mr. Bowman, Your Honor. Mr. Bowman, can you state your full name for the record?
My name is Raymond William Bowman.
I have before me a plea form. Is that what we're doing?
Yes, that's correct, Your Honor.
Plea form indicates that the defendant will plead count 2, possession of a weapon in a weapon-free school zone, 9 misdemeanor. And upon a successful plea, that charge count 1 would be dismissed.
That's correct, Your Honor.
Is that a correct statement?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Raymond William Bowman.
Sir, it is this court's understanding that you are pleading no contest to the charge of possession of a weapon in a free school zone, in a weapon-free school zone. Is that correct?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, sir.
Two things about a no contest plea I have to make sure that you understand. The first thing about a no contest plea that you have to understand is that it means that you are not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea.
Your Honor, potential civil liability.
And understanding all of that, sir, you still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
I understand, Your
You
Honor.
understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am on probation in Wayne County.
Were you on probation at the time of this offense?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Michigan Department of State Police report for their case number 4613-20. Any objection to the court having reviewed that report?
No objections, Your Honor.
Counsel, there is not an indication of a school, the zone.
It would just be to the higher,
So accepting the higher,
there's no good misdemeanor for a firearm.
so in looking at that, then, all right. Sir, if I do accept your plea, I have to have you understand that any sentence evaluation, if there were any or any recommendation, the court would not be bound by if you committed any misconduct as defined in the Michigan court rules. You understand that?
Yes, Your Honor. I
You
do.
also understand that you would not be entitled to withdraw your plea.
Yes, I understand.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
The defense is satisfied, Your Honor.
And based upon the police report, the court would find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. The court will accept the defendant's plea to no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
July 9th, 2025.
July 9th, 2025, 9 a.m. That's before me.
Your Honor, may I address bond when appropriate?
You may.
Your Honor, my client is asking to be released on a PR while he waits his sentencing. My client is unfortunately very ill. He needs to go back to the hospital. He's actually due to have a procedure done today, correct, at 3 p.m. It's quite an intense procedure. He's also going to be
Is this the only thing holding him?
in here. Yes.
Judge, he has-
What do you mean here? Yes.
He has a hold out of Wayne for the DUI. He has bench warranted 4 times in this case already. So people think that he should be held until they receive that permission.
The bench warrant, I believe, was due to him being hospitalized, and that's why he failed to appear previously.
What about the bench warrants in?
I'm to be released to treatment from Wayne County. That's why my sentencing would need to be, I'm going to the Salvation Army, and I need it set up on Zoom. So if you were to release me, I would go to Wayne County Jail and wait for treatment to pick me up, and then I would be at the Salvation Army there.
Anything else?
Nothing further, Your Honor.
I don't think it's appropriate given the defendant's track record in this case and the very fact that he has another hold to release this defendant. Therefore, the motion for bond reduction in this case at this time is denied. I'll be seeing him next week. So
Understood, Your Honor.
thank you.
Thank you, Your Honor.
Court calls case of the people versus George Bowman.
Zachary, your word on behalf of the people.
Assistant Public Defender Nicholas Buckovich on behalf of Mr. Bowman, who is now approaching. May you please state your name for the record?
George Bowman.
Go ahead.
At this time, Your Honor, be setting this matter for preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available on the 15th. What is that?
Right.
Yeah, I do feel threatened, but Alan doesn't. What is that? We don't know. Have we ever figured out what it is? That happened to me?
Every morning.
No, I'll be good. Don't worry about it. No, I'm all right, man. Preliminary examination will be set July 15th, 2025, 9 a.m. That is before Judge Washington.
It'll be here. Yep.
Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Troy Brumfield.
Your Honor, Alexis Plumey appearing with and on behalf of Mr. Brumfield. And Mr. Brumfield, could you state your full name?
Troy Brumfield.
And Your Honor, I do have a green sheet here. I am asking for an adjournment. I was not aware that Mr. Brumfield was in custody until this morning, so I would need some time to go over discovery with him. And I would again like to address.
And you're also, you want to address this bond? Have
would.
you seen the new complaint for a conditional bond violation?
I have.
Okay, go ahead.
Your Honor, Mr. Brumfield was just arraigned last week. I do understand that there were 2 violation reports filed, one for a failure to test on the SoberLink device that was ordered, and the other for a new complaint with the allegation that Mr. Brumfield allegedly took some food from the University of Michigan Hospital. I would still ask Your Honor to consider a personal recognizance bond here with a scram tether rather than a SoberLink. I think that might be easier for Mr. Brumfield to test. And it's my understanding that he.
Are there new charges that are going to be coming from that?
Your Honor, that is just new. We have not received a new warrant request yet.
Got it.
Receiving it shortly.
Yes, and it's my understanding that he's not being held on anything to do with the new report.
Any response from the people?
Your Honor, we would reject the defendant's release at this time, considering the 2 separate bond violations with criminal history that does include fraud and his prior illegal UIs. If you were considering his release, we would ask for that scram tether, considering that he did not test at all on this. So
That's part of the problem. He didn't test, and that is allegedly out there, at least, or places himself in a position where he's committed another offense.
I understand, Your Honor, and I think the scram tether would solve that testing issue. And I would just emphasize that it was just a few days that he was not testing. I did attempt to reach out to him when I found out, but I believe we just didn't have updated contact information for him. Would still ask the court to consider a personal bond and a scram.
Motion for bond reductions denied. Probable cause conference is adjourned to July 17th, 2025, 9 a.m. Bond will continue as denied at this point. She's sloughing off. Court does call the case. The people of the state of Michigan versus Grace Brenner.
Good morning, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Brenner. Your Honor, can we approach?
No, she ran at me. I had to throw it back.
Oh.
All right. Record should reflect we had a bench conference in this case. Defendant is not present. Court will issue a bench warrant for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately.
Yes, sir.
What's that way? Court calls the case People versus Robin Finney.
Your Honor, Alexis Plumey on behalf of Miss Finney, who is approaching. Miss Finney, could you just say your full name?
Yes, Robin Lee Finney.
Thank you. And Your Honor, we are just asking for a brief adjournment for plea negotiation purposes. And I am not asking to address bond.
Shocking. Probable cause conference will be adjourned to July 17th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Wow. Court calls the case People versus James Lee Harbin.
Kedma Dadush on behalf of Mr. Harbin, who is appearing by Zoom. Mr. Harbin, can you please state your name for the record?
James Lee Harbin, Harb as in boy I-N.
Your Honor, we are requesting an adjournment so we can continue plea negotiations with the prosecution, please. Already did it.
Where is he held? At St.
No.
George.
He's at
Got it. That's the reason for the Zoom. Is
Valley. I forget the Villa, sorry. Let me get the exact name. Villa at Park Ridge.
Got it.
The rehab center.
July 24th, 2025, 9 a.m. Bond.
Thank you.
Court calls case of the People versus Frank Clark.
Dadush on behalf of Mr. Clark, who should also be appearing by Zoom. Mr. Clark, can you state your name for the record?
Frank Clark.
Your Honor, we are requesting a 1-week adjournment. We have a resolution on this case. We just need 1 more week to finalize that.
I'm not going to do it that way. Probable cause conference, he's out of custody, will be July 17th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case of the People versus Kyle Humphreys.
And
Assistant Public Defender Nicholas Bukovich appearing on behalf of Ms. Humphreys in both matters. There should be 2 cases, Your Honor.
Yes. All right, what are we doing?
Your Honor, I'll be requesting a brief adjournment to obtain outstanding video discovery in the case that ends in 0889, and I would be requesting to address bond briefly.
Did Plumey put you up to this?
No, Your Honor.
No, go ahead. I will adjourn these out to the 17th, 2025, 9 a.m. Go ahead.
Yes, Your Honor. In the case that ends in 0889, Mr. Humphreys currently has a PR bond. From my conversation with my client, I do believe he'll be held based upon his bond in his other case. So I'll just be requesting a nominal cash bond to allow him to obtain time for
Which
credit.
case is he on?
In the case 0907, he has indicated to me that he cannot currently post that bond. In case 0889, he currently has he was granted a personal reconnaissance bond. So I'll just be asking for a nominal cash bond to allow him to get credit for time served in both matters. I would also be asking for a release to treatment in both cases, and I understand the court would like an order filed with that.
Just filed an order to say about release anybody to treatment if that's what they want. I'm not going to have a problem with that unless there's some objection. Just get a stipulation to do that.
Yep, and I will get that to the court as soon as possible, Your Honor.
All right, so I will adjourn the matter to the I'll adjourn this matter to July 17th, 2025, 9 a.m. With reference to his bond in case 09 or 0889, I will reset his bond to a $1,000, 10% off. All right, so that he receives credit. You'll have to. Thank you. Court does call the case People versus Sean Cotton.
APA Richard McDuffie for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cotton, who should be appearing via Zoom.
Mr. Cotton, please state your name.
John Cotton.
Yeah, and at this time, we'll be requesting an adjournment to for the client to pay some restitutions toward his offer.
PCC will be adjourned July 17th, 2025, 9 a.m. Bond continues. Court does call the case of People versus Chad Jones.
Please state your name for the record.
Chad Jones.
Your Honor, we are requesting a brief 1-week adjournment for a global resolution. The prosecutor needs 1 more week to get in contact with 1 witness. So we have 2 on board. They just need 1 more.
Some green sheet.
Yeah.
You're gonna be able to get it all accomplished in 1 week, so I'm not gonna be back here and then asking for another week.
Yes, Your Honor, everything is set except for one thing, and once that's addressed.
Probable cause conference will be adjourned to July 10th, 2025 on all 4 cases, or 3 cases. 9 a.m. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Donovan Drunkowski.
APA Richard McDuffie for the people.
Also, basically on behalf of Mr. Drunkowski, but not with him, Your Honor. Unfortunately, I have not had contact with my client. I'm unsure of his whereabouts at this time.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately.
Your Honor.
Court does call the case People versus Daniel Franklin.
Andrew Field is appearing on behalf of the people, Your Honor.
Good morning, man. Please, this Honorable Court, Kareem Johnson, appearing on behalf of Mr. Franklin.
Pardon? Your name, sir?
Daniel Franklin.
Thank you. All right, what are we doing on this case?
I spoke with Mr. Johnson. I don't know what has been, I believe he has been tendered discovery, and I think we're just looking to set this matter for an examination.
Is that a correct statement, Mr. Johnson? You'd like this matter set for prelim?
Yes, Your Honor, and we're asking that the prelim be set out a ways. I believe the people will be calling a cooperating witness who is in federal custody. Because of the likelihood that this witness may become unavailable down the road, I will be asking for the people to present any and all information they have relevant to cross-examination under US v. Giglio. And I think the people may need some time to get that. And I don't know if the people are even in possession of the federal indictment in which this witness is cooperating under and giving this testimony, but I would like to have that before exam as well.
Your Honor, I have no problem with that. I have no problem with setting this matter out. As the court may remember, Mr. Franklin is being held on another homicide case that is pending before Judge Conlon with a trial date well into the fall. The reason.
So why am I setting it for exam if everything's not ready?
This cooperating witness is currently being held at FCI Milan. The moment we have an examination date, I can give a writ to them. They won't transport him. Otherwise, it sounds like he's going to eventually go to West Virginia, and I'd like to have that writ before the Bureau of Prisons transport him transports him out of the state. So the date.
Especially in West Virginia, because people don't come back. No, I'm kidding. I love West Virginia.
I don't know.
Okay.
And so that would be the reason I know, and as I spoke, Mr. Johnson and I spoke yesterday, and I believe we're on the same page.
All right. So how, to get accomplished everything, how much time are you guys looking at? I get why you want a date out. I'll set the exam, but.
Perhaps, I don't know what the court's availability is. I'm looking into kind of August.
Mid-August. I can do August 12. I can give you a prelim date on August 12.
That works for the people, that works for Mr. Johnson.
Your Honor, on August 12th, I have another homicide exam in the Lansing District Court.
Gotcha. Well, that's my only set PE date in that date. Did you want me to kind of give you a Monday and that way more flexibility to do that?
August 11th, if the court is available that day, that would be perfect for me, Your Honor.
Monday would be fine, and just for the court scheduling purposes, I wouldn't expect this to be something that would take more than half a day. So
Okay.
that'll be a full day examination.
That's okay. So what I'll do is I'll just put it on my docket. I should have asked, do I have the 11th available? And if we don't pick a jury selection in the morning, so I can set it in the afternoon. Oh, I did set a note here. Okay. All right. I can do Monday the 18th. Will that work for you, Mr. Jones?
I'll be in a jury trial in the Washtenaw County Circuit Court on the 18th, Your Honor.
No way. No, I'm kidding.
The 25th works for me if that works for the court.
No, because I'm gone. Right. Well, August, I know it's going the other direction, but would August 4th work?
I think August, at least from the people's perspective of getting the information to Mr. Johnson, August 4th would work for us.
Mr. Johnson, August 4th work?
I will be in trial August 4th, Your Honor.
The whole day?
Yes, Your Honor.
All right, give him a Tuesday. I don't know what Johnson's schedule is. I don't know why I'm setting around Johnson anyway.
My other thought is if we could set it on a Tuesday, perhaps that 12th, knowing that we would then get closer to the date and perhaps talk with the court about a skip to move it. As long as I have the date to hold this witness, I don't care if we move it. I can send.
Why don't I do this then? And then this way you can kind of figure it out, and then we can move it to give you more flexibility in terms of dates, because then we'll be able to figure out my dates a little bit. I'm gonna set it on July 22nd. Okay, with the understanding that you guys may have to move it, but then we'll move it on my docket.
That's fine.
Okay.
Yes, Your Honor.
So preliminary examination in person will be set July 22nd, 2025. That's at 12 noon. So that's an afternoon prelim docket or PE docket for me. All right.
Thank you,
Thank you, Your Honor.
All right.
Mr. Johnson, I'll contact you early next week and we can go over
Yes, sir.
everything, okay?
All right. Thank you, Mr. Johnson. Court calls the case of the People versus Dave Ellington.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Ellington. Mr. Butcher now. Your Honor, Mr. Ellington will be waiving his right to a preliminary exam. I'd ask if the people would place the offer that was extended on their record.
Your Honor, Mr. Ellington is charged with financial transaction advice. Without authorization. The offer is.
The offer is to an attempt. Is that your understanding?
Yes, Judge. Thank you.
And sir, you're waiving your right to a preliminary examination?
Yes, sir.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right? People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Your Honor, we would acknowledge receipt of the information, waive formal reading. My client would stay mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set
August 8th, 2025 at 1:30 with Judge.
August 8th, 2025, 1:30, Judge.
No, you're good. This is just your notice.
Oh,
On continue.
Thank you, Judge.
thank you.
All right, I'll finish this.
Court calls case of the people versus Jalisa McDow.
Your Honor, Amy Riser, Your Honor, Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Ms. McDowell.
Okay, permission to practice is granted.
Thank you, Your Honor. Ms. Dowd, could you say your name for the court, please?
Jalisa McDow.
Thank you. All right.
Your Honor, we would like to request the court set a date for exam in this matter, please.
All discoveries complete.
Yes, Your Honor.
People have their witnesses available the 15th?
Yes, July 15th.
Yeah, July 15th. Will that work?
Yes. And to address the issue.
Preliminary examination in person will be set July 15th, 2025. 9 a.m. That is before Judge Moore. As to bond.
Thank you. Your counsel has been provided with several of the defendant's jail calls. And we're asking that her calls be revoked at this time. She's actively trying to have third parties contact the minor child in this case to have her recant. So we're asking that her jail calls be revoked and if necessary, a date be set for a hearing.
Your Honor, I've listened to the calls myself, and while in some regards, Ms. McDowell does talk about her case to people, she very rarely makes requests. Her tone is not demanding or threatening or coercive.
Rarely makes requests?
Well, I mean, I'm talking about a request in general, Your Honor. So, but there are a lot of conversations, and for the most part, her tone is not demanding or threatening or coercive in any way. And mostly she's just talking and trying to communicate with her mother, her grandmother, and her cousin and other family members.
But are there indications that not only, because those would be third-party contacts, but is there an indication where in any reasonable fashion it could be read she's making a request for somebody to recant their story?
Your Honor, I believe that in most of the situations and most of the phone calls that we heard, she wasn't making requests as much as just expressing how she was feeling about certain issues with her grandmother and her mother and the people who are taking care of her children right now.
It really doesn't answer my question, but that's fine.
We did meet with Ms. McDowell yesterday. We talked about that. I will say Ms. McDowell was very candid. We went through some of the phone calls together. Her understanding, she had no intent to disobey the court's order. She's not in any way trying to intimidate or coerce anyone to come to court or to not come to court. Her position is that she has other children involved. She was getting messages that these children are left unattended at her home. She's very concerned about the safety for them. That has now been resolved. After my conversation with McDowell, she even said, I don't plan to be on the phone anymore. I was never trying to disobey the court's order. That was not my intent, but obviously she has concerns for the safety and well-being of other children. that are currently, they now are placed with someone that she knows, and she does not have that same concern for their safety at this time.
If I could, Your Honor, provide an offer of proof, just an excerpt from one of the calls.
Yes.
This is the defendant speaking on June 19th, 2025. She's got mental problems. She's got mental problems. Me and Melanie don't speak because she done put $300 worth of damage in her house. I think you all will speak up for me and share her stuff too. Like, that's not fair. That's at 2:11 in the call. And at 5:08 in the call, the defendant says, I probably could get her a ride to court like that. I know I can get unintelligible. Who she's speaking with, I believe it's the grandmother. Let me give her a ride. Let me get her a ride. I'll take Talisa out there. Let me give her a ride out there. The defendant, what you talking about? Is she really coming to the court? And the grandma said, we haven't talked about that. We haven't talked about that. And the defendant responded, no, you got to talk to her about that, Mom. I mean, I could go on and on.
Seems enough for me. Motion to revoke defendant's phone privileges is hereby granted. Defendant's phone privileges are hereby. You can always ask for a hearing on that. All right. Thank you. Court calls the case People versus Darius Grady.
Good morning, Your Honor. Amy Advisor appearing on behalf of the people.
Good morning, Your Honor. Roba Hamden requesting permission to practice pursuant MCR 8.120 under the supervision of First Assistant Public Defender Jay Ballinger.
How's that going?
It's going well.
Is it?
I think so.
Is he treating you okay?
You know.
Okay, we'll talk later.
We'll talk later.
Permission to practice is granted.
Thank you, Your Honor. I'm here with and on behalf of Darius Grady. Can you please state your name for the record?
Darius Grady. Thank you, sir.
Your Honor, we are asking for a 3-week adjournment on this matter, awaiting a mitigation letter.
And no objection to that adjournment.
Probable cause conference will be adjourned to July 24th, 2020.
Was that July
22nd, 2025. You know, did you catch the other one?
Yeah.
All right. July 22nd, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you, Your Honor.
That's all your fault. Calendar. Court calls the case People versus Demond Bransford.
And Assistant Public Defender Nicholas Buckfitch on behalf of Mr. Bransford, who's now approaching. Bransford, can you please state your name for the record?
Demond Bransford.
At this time, Your Honor, we'll be requesting a brief adjournment. Mr. Bransford was interviewed by the Drug Treatment Court people this Monday, so we're just waiting for a response to that.
Would a response you believe come before the 17th?
I believe we should be able to get a response by the 17th, Your Honor.
All right. Probable cause conference, July 17th, 2025, 9 a.m. Bond continued. Court calls case People versus Cortez Gray. Oh, boy.
Advisor on behalf of the people.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Tortio Feaster.
Showing up in that North Carolina view. She doesn't even understand why that makes my eyes go red. Permission to practice is granted. What are we doing?
Your Honor, we are requesting an adjournment in this matter. We were unable to get in contact with Mr. Gray, but now we have his correct phone number.
July 17, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court. What? Oh, I'll explain later. The whole North Carolina thing, like Tar Heels. Go to Tar Heels? Okay, that's why. Court calls the case People versus Devonte Jackson.
Good morning, Your Honor. This is Attorney.
And Alex Warren Green on behalf of Mr. Jackson.
Yeah, what is this?
Mr. Jackson, can you state your name for the court?
Devonte Jackson.
Your Honor, today's the date and time for probable cause conference. At this time, we are asking the court to set the matter for preliminary examination.
All discoveries complete?
I believe so, Your Honor.
And would the people have their witnesses available on the 15th? Preliminary examination in this matter in person will be set July 15th, 2025, 9 a.m. That is before Judge Washington. Bond continued.
Thank you, Your Honor. I'll talk to you soon, Devonte.
Court calls case People versus Susette Hampton.
Stephanie Cannon on behalf of Ms. Hampton, who's appearing to the right. Ms. Hampton, could you please state your name for the record?
Yes, Susette Hampton.
Your Honor, we're just asking for a 2-week adjournment on this matter for negotiation purposes.
July 17th, 2025, 9 a.m. Bond continued. Thank you.
Do you need?
Court calls case of the People versus Paris Lester.
Him on behalf of Mr. Lester. Can you state your name for the record?
Paris Alexander Lester.
You're requesting an adjournment.
We're requesting an adjournment, and I sent a motion to modify bond conditions to get him released into treatment, Your Honor.
You did it by motion as opposed to stipulation.
I believe it was a stipulation. I just worded it differently. I believe it was a stipulation.
Really?
Yes,
Usually those are signed by both sides. It's okay. Is there any objection to their motion? Okay, I'll grant your
Thank you,
motion.
Your Honor. Yeah.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Court calls case People versus Marcus Harris.
And Alex Warren Green on behalf of Mr. Harris. Mr. Harris, can you
How
state your
doing,
name?
Mr. Simpson? Marcus Harris.
I'm doing okay.
I seen you guys.
What'd you say?
It's been a minute since I seen you, but how you doing?
I'm doing okay.
All right.
You're back.
Been a while, but yeah, I'm here for the moment.
And you look. So the last time you were here, were you allowed to wear shorts in my courtroom?
No.
No, right?
Should I put on to get here, put some on to get my butt up in? Because last time I was here, you took me to the back for coming late. That was a while ago, so I'm sorry about that. I will make adjustment on this the next time.
You believe it? You don't know?
Oh, be good.
All right, go ahead.
Your Honor,
you will.
I'm asking the court to set this matter for a preliminary exam.
All discoveries complete.
So, Your Honor.
People have their witnesses available the 15th.
My best, Your Honor.
Preliminary examination in person will be set July 15th, 2025, 9 a.m. before Judge Moore. Bond continued.
Thank you, sir. You have a blessed one.
You take care of yourself. Court calls the case People versus Ahmad. Is it McWally?
I'm sorry. Can't get rich with the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Matwali, who approaches. Mr. Matwali, can you please state your name for the record?
Ahmad Matwali.
And Your Honor, if we may briefly approach on this.
Okay.
Thank
you. Any other, I've received and reviewed the report. Are there any other additional?
No other proofs, Your Honor, from the defense.
Nothing from the people we said, nothing.
All right, based upon the report, the court has reviewed that report. The court would find that the defendant is at this time competent to stand trial, would specifically find that the defendant can understand the nature and the objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. And you wish this matter set for preliminary or for PCC, is that correct?
That's correct, Your Honor. One more extended PCC, and I imagine at that time we'll probably be waiving up to circuit court.
I'll set a probable cause conference in this matter for, given the circumstance you explained, the 22nd or the 29th, or 22nd or the 31st.
22nd.
My client is asking for the 22nd, Your Honor.
Got it. Probable cause conference, July 22nd, 2025. That's at 9 a.m.
Thank you, Your Honor.
Round continue. Thank you. She's doing. I know, but you didn't turn the camera back.
Oopsies.
You turned it. You gotta follow through. Court calls the case, People versus Dashir Hassani.
Anna Mackey on behalf of Mr. Hassani, who is to my right. Please state your name for the record.
My name is Dashir Hassani. And my apologies for wearing shorts, Your Honor. I was not aware. And flip-flops.
Did you just come from the beach or something?
Mr. Brown told him it's summertime and hot in the streets. That's what Mr. Lauren Brown said.
Lauren Brown said that?
Sure did.
And said that this was appropriate?
Look at him smiling back there.
Yeah, I know. I see him out there. Go take Mr. Brown's pants and come back. You know? All right. I know Mr. Brown didn't tell us to show up that way. I don't know what man he's trying to say. What are you looking to do?
The green sheet, Your Honor, adjournment. We're waiting discovery.
Fine.
Thank you.
It is a green sheet. She's right. Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond continued.
Thank you. And I'll make sure Mr. Hassani is in pants and shoes.
Sure.
Thank you.
Will do.
Court calls the case, People versus Dale Miller.
Defender Hannah Apple appearing on behalf of Mr. Miller, who's approaching now. Mr. Miller, will you state your name for the record?
Dale Joseph Miller, the Alpha and Omega. Will you give this to him, please?
Probably not, but I'll look at it first.
Okay.
Thanks. Judge, Mr. Miller was found incompetent but restorable.
Yes.
The opinion that I have has this case also listed on it. I'm not sure. I think maybe.
What's your date of your report?
I want to say it was like May 6th.
I have a May 8th.
Okay,
report.
May 8th.
I'm opining that he's incompetent to stand trial, but likely to obtain competence was the proper course of treatment.
Correct. So I don't know if this one just got behind the other three, but I have an order prepared.
All right.
The court to sign. He's awaiting treatment at the forensic center. And just for the court's information, next review date on those other three matters are the 14th of August.
Am I allowed to speak real quick?
No, I wouldn't recommend that.
I just want to let you know I'm the original son of God, the Alpha and Omega, mighty God, the only child conceived from Yahweh, Angelica, and the Holy Spirit. The devil is inside Barack Obama, Azazel. He was at Area 51. Semyaza, his sidekick, is inside Pope Francis. The book of Revelation is about me, and I have 12 sisters that are down here too. Christ comes from me in heaven too. I sent him into this world. I created the heaven and the angels. Azazel kissed my wife Danielle twice in heaven. That's why he was put down here. He caused the fall, sending a male into the Garden of Eden to sleep with Eve. So he's paying the price now, and he is going to be dealt with soon. I'm going back to heaven soon. The rapture is going to happen soon, and I will come back after 7 years. I'm the Alpha and Omega, the Lion of Judah. Christ is the Lamb of God. I put everything in that note she's supposed to give you, but you guys won't let me speak. Lauren, the girl this case is over, is one of my 12 sister wives.
Okay.
About the case.
And
All right. I'm
letting you know, you guys haven't given me a chance to
Let's
defend myself. I
talk.
try to let you know.
I let you talk, but now I'm done.
Okay,
Okay.
been warned. You will be dealt with. I'm the real judge of this world.
Okay.
You're going to hell.
I'll await that.
Thank you.
September 4th for 2025, 9 a.m. Round continued. You know, I've heard that same thing from Feaster. Every conversation I have with him. Every conversation with Feaster starts that way. I don't really think it's up to you. Court calls the case, people versus Alicia Henderson.
If you're arrested for people.
Hannah Mackey on behalf of Ms. Henderson, who is to my right. Please state your name for the record. Alicia Henderson.
So that you know, because I criticized you. I felt safe that way. You got me. You got me. It's just, thank you. All right, go ahead.
Your Honor, we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
Before we do so, Your Honor, I was not here at the last hearing, but I do know that we adjourned to explore restorative justice resolutions in this case. The notes that I have from the previous APA that covered indicated that both parties were in fact agreeable to the restorative justice resolution, which would have them at the dispute resolution center, resulting in the ultimate dismissal of this matter if that is successful. However, there was a bench warrant issued, I think, because she failed to appear at the last hearing, as well as the required paperwork not having been submitted yet by counsel. So I do want to confirm on the record before we set this for exam that the parties on defense side, or defense rather, is rejecting the restorative justice resolution before we proceed to exam.
That is correct, Your Honor.
Which part?
All
of it? You're rejecting it?
We are.
We can go ahead and do what we were going to do just about 20 minutes ago.
The bench warrant was recalled. Because
Yes, it was.
able to.
That's why she walked in.
Yes, sir.
And now, what do you want me to do?
Set for exam, please.
Please? Oh, so why was Janaza like whispering?
She just wanted to talk to me.
So it wasn't anything about the case? No? Okay. All right.
We'll go ahead, we'll set it.
No, go ahead. What were you going to say? I've got all the time in the world.
Because the restorative justice resolution required contact, we normally request that those conditions are changed for consensual contact so that resolution can occur. I'm not certain if that happened at the last hearing or not, so we'll do it right this moment. But before we are done with the case, I did want to confirm that standard no contact conditions are in effect.
My client hasn't been in contact with the complaining witness regardless, so.
So would the people have their witnesses available?
What was that date, Your Honor? I'm sorry.
15.
We will try our best.
Preliminary examination in person, July 15, 2025, 9 a.m. before Judge Washington. Bond will continue. I don't see that any conditions were changed.
Okay.
So whatever the original conditions are still in. Court calls case People versus Sher Nyali. Or Nyali.
Your Honor, who am I appearing with and on behalf of Miss Nyali? And Your Honor, she will be waiving her right to a preliminary exam and proceeding to circuit court. I have gone over that with her.
Ma'am, is that correct?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over to circuit court on a single count.
Your Honor, we acknowledge the receipt of the information and would waive its formal reading and stand mute at this
Defendant
time.
having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 17th, 2025 at 1:30 with Judge Slay.
July 17th. 1:30, Judge Slay.
Thank you, Your Honor.
Bond will continue. Okay. Thank you. Court calls the case, People versus Dottton Howard.
Hannah Mackey on behalf of Mr. Howard.
The shoes match too.
My nails too. They all match.
Oh, I was gonna do that. No, God. Go ahead.
Please state your name for the record.
Dottton Howard. Thank you, sir.
Your Honor, request an adjournment. We're waiting for discovery. Our office has not received any yet.
Discovery.
Yeah.
The adjournment, I believe that has gone, that was really to discover process, so.
July 17th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
So all I have left is. Court does call the case of People versus Garrett Penagle.
Penagle, Your Honor.
Penagle, of course.
Assistant Public Defender Jay Bellinger on behalf of Mr. Penagle, who approaches. And Mr. Penagle, can you please state your name for the record?
Garrett Penagle.
And Your Honor, while I can say that my client is not awaiting the rapture, he is awaiting a response as to.
You really didn't have to, but go ahead, sir.
He is awaiting a response as to 20 seconds recovery court. I just submitted him for that yesterday. I was informed by Ms. Sample that he will have an answer no later than the 24th. And at which time I imagine we'll have some sort of resolution going up. I'm hopeful.
So is the answer you think coming on the 24th?
I think that they meet on the 24th, so I believe it will be.
Okay. So what I'll do is I'll adjourn this out to July 31st.
Thank you so much.
2025, 9 a.m. bond will continue.
I'll have an answer for you by then.
Oh, she's using her big words, asking me if we're doing recalls. Apparently we are.
Thank you, Your Honor.
Thank you.
I got this.
I'm doing all this. What? Are they ready? Do you know if they're ready? Or you just hand it? What?
I'm following instructions.
I'm gonna call what I want. I know. Court calls case People versus Tyler Redmond. Deal's ready. I'm just here.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Redmond, Your Honor. Mr. Redmond, state your name for the record.
Tyler Redmond.
Your Honor, we're still waiting for an assessment to be done from the Circuit Court Sobriety Court. At this point, I would ask the court to, we thought it was
22nd.
Yes, yeah.
Sobriety Court.
Yeah, at this court, at this point, I'd ask the court to set an exam and we'll continue to look into that option as well. I've talked to the assistant prosecutor and I've told him that if there is an assessment done and we're in a position to waive or resolve, I'll certainly give him notice in ample time to call if any witnesses.
So he hasn't even been assessed.
No, Your Honor, we thought that was going to happen by the 26th, and I think there are a couple We're a little bit behind.
So you want an exam instead of adjourning it to see if you can make that happen? I mean, either way, it doesn't matter to me. If we have the exam, I can still do the assessment?
Let's set an exam, Judge, if the court's okay with that.
No, discovery is complete to your knowledge.
Yes, Judge, to my knowledge.
People have their witnesses available the 15th.
Yes, Your Honor.
Preliminary examination in person, July 15th, 2025, 9 a.m. That is before Judge Moore.
Yeah.
Okay.
Okay, all right.
Bond continue.
Thank you, Aaron.
I'm sorry. Jeez. Court recalls the case. Oh, ready. No. Court calls the case People versus Nikita Roberts.
Here, Richard McDuffie for the people.
You do.
Mike Gaddy, Assistant Public Defender on behalf of Ms. Roberts, who's here to my right. Your Honor, state your name, Ms. Roberts.
Nikita Roberts.
Thank you.
Welcome.
Your Honor, I'd ask to set this matter for an exam.
For exam,
Yes,
all discoveries complete.
I have reviewed the file. It looks like it is, Judge.
I believe so. I did want to just confirm with Mr. Gaddy.
I'm happy to talk about a global resolution. I've spoke with Mr. Ward about that as I was instructed to do, and he and I are going to continue talking, Judge.
Okay. People have their witnesses available this 15th.
If I can be
Their
heard.
examination in person, July 15th, 2025, 9 a.m. That is before Judge Washington.
If I can be heard on time, Judge.
Sure.
Thank you. Your Roberts has been in custody for several weeks. Excuse me, I had a frog in my throat. She does have a place to live. She lives locally. She would, I think, I'd ask the court to give her an opportunity to avail herself of using a scram tether to ensure that her appearance in court, as well as any testing or other monitoring provisions that the court would deem necessary to ensure her appearance. I'd ask the court to, her bond is set at $25,000 in this matter. I'd ask the court to, she does have a couple other matters that are pending. She has the matter in circuit court that Mr. Ward and I have also discussed. I believe her bond is $50 in that matter. Her bond's $100. Her bond is $100, I think, in a 14B court, 14B district court case where I think it charges a legal entry. So I'd ask the court to consider reducing this bond to something that she may be able to post with or personal cognizance with any conditions that the court deems necessary to ensure her appearance.
Response.
Your Honor, I would object to any change of bond conditions right now. Ms. Roberts also had a domestic violence case pending. I understand it was a final settlement and may have been dismissed yesterday.
It was.
That was a newer case, however. Ms. Roberts, this case is a bit older. And it looks like looking at the previous notes, there was a bench court issue for $25,000 cash assurity for failure to report to court, as well as community corrections. I think a subsequent violation for community corrections as well. I'm concerned, obviously, about the substance use in this case. I don't think that, given her history of failure to appear and some new offenses in the interim and failures to appear on this case and other cases in circuit court, that we can trust Ms. Roberts to, on her own, comply with court orders and show up.
Your Honor, the DV case was dismissed yesterday in my note.
Does she have any other things pending at this point or no?
Nope, just this matter, the illegal entry case in 14B, and there's a circuit court case with a $50 bond, Judge. There is a whole
$50 bond in her circuit court?
Yes.
That was just because she had a bond in something else.
Yes, that's my understanding. It's a very old case. It was bench warrant. I think for some reason I don't think the bench warrant ever got on lien because the jail didn't know about it until it was brought to their attention during the pendency of this case.
Granted. Defendant's bond is set at $5,000 personal recognizance bond. Defendant is to report over. We'll do new community corrections test. She's to report over for once a week testing.
Okay. Thank you, Judge, and we'll work on the other bonds as well. But thank you.
Thank you, Your Honor. Thank you. Calls case People versus Timothy Stevens.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Stevens, Your Honor, who's standing here to my right.
Sir, your name?
Timothy Stevens.
Thank you.
Your Honor, at this time, we'd ask the court to set this matter for a preliminary examination. Ms. Tana and I have it and I discuss it.
Have what?
Ms. Tana and I have had an opportunity to discuss this matter. We're going to set it for exam.
Discovery is complete.
Yes, Judge.
People would have their witnesses available the 15th.
I believe so, yeah.
All right. Preliminary examination in person, July 15th, 2025. 9 a.m. That's before Judge. Judge.
Thank you, Your Honor.
On continue.
15.
Court calls case People versus Leo Stringa.
And Alex Warren Green on behalf of Stringa. Can you state your name?
Leo Stringa.
Thank you. Okay. I have before me two plea forms. It's going to be pleading to 2 counts of in 2 different cases to retail fraud, second degree, the 1-year offense. On a successful plea to that charge, count 1 would be dismissed. There's also an indication that a case out of 1482, which is a retail fraud 3rd degree, would be dismissed on a successful plea in these cases. That's all right.
And that's our full understanding, Your Honor. Mr. Stringa is asking the court to consider a no contest plea to both of those counts.
Do I have reports? It does say no contest plea. Yes, I do. I saw these reports. All right. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth, self you got?
I do. Leo Stringa.
Sir, it is this court's understanding that you are going to be pleading to 2 charges of retail fraud in the 2nd degree. Is that your understanding?
Yes, it is.
All right. Those are misdemeanors punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. You understand what a no contest plea is?
Yes, my attorneys described it.
All right. 2 things about a no contest plea. I have to make sure that you understand it. First of all, means that as to each of these cases, you have no desire or do not wish to contest these charges. You understand that?
Yes, I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand also, sir, in one of your cases, the case ending in 5508, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Valvo in the 15th District Court.
Okay.
You understand that?
Yes.
Basis for the no contest, please.
Lack of recollection, Your Honor.
All right. Sir, to the charge, I'll start with the 15th District Court matter. To the charge of retail fraud, 2nd degree. I'll just give you an offense date. Having occurred on November 20th, 2024 in the city of Ann Arbor, how do you plead?
No contest, Your Honor.
To that same charge, having occurred on November 20th, 2024 at 3825 Carpenter Road, that being the Meyer and Pittsfield Township, how do you plead?
No contest as well.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
Yes, I have.
Any question regarding any of those rights?
No questions.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading no contest, you're giving up those rights as well as all the rights in that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, actually.
No, the probation that I was on I'm done with.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No,
Has anybody threatened you or coerced?
no.
You're doing this voluntarily?
Yes, on my own accord.
And of your own free will.
That is as well.
The court has been provided and has reviewed University of Michigan Department of Public Safety and Security for their case number 24-903-06211, as well as Pittsfield Township Department of Public Safety report for their case number 24-19305. Any objection to the court having reviewed those reports?
None from the defense, Your Honor.
Based upon a review of those reports, the court would find that there's a sufficient factual basis to determine the defendant's guilt. Sir, you understand that if I accept your plea in this case, between the time of the acceptance of your plea and the time of sentencing, if there's misconduct committed by you as defined by the Michigan court rules, you would, one, not be entitled to withdraw your plea, and two, any resolution or evaluation regarding this case, the courts would not be bound by in terms of sentencing. You understand that, sir?
Yes.
All right. Is counsel aware of any other promises, threats, or other inducements that have caused this plea?
None from the defense, Your Honor.
Has the court complied with the court rule in both of these matters?
And the defense is satisfied.
Court will accept the defendant's plea of no contest to count 2 in both cases. Count 1 is dismissed. In the 15th District Court matter, a pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in the 15th District Court matter will occur on July 29th, 2025 at what time? 9 a.m. before Judge Balbo. In the other matter, court does accept the defendant's no contest plea to count 2, count 1 being dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in that matter will be July 9th, 2025, 9 a.m. before me. Bond in each of these matters will continue. Thank you.
Thanks, Leo. Thank you, Your Honor.
Thank you, Your Honor. Clerk calls case people versus John Terry.
That is for the people. Your Honor, Alexis Pluma appearing with and on behalf of Mr. Terry. Mr. Terry, could you state your full name when you get up here?
John Martin Terry.
Thank you.
And Your Honor, I believe the court has received a plea form as well as a signed advice of rights form. Mr. Terry will be pleading to an added count 3 of controlled substance use, and counts 1 and 2 will be dismissed.
That is what the court has in front of us. Is that a correct statement? All right, let's have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
John Martin Terry.
All right. Okay, sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance.
Yes, sir.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking a plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, sir.
All right. Understanding all of that, you still wish to plead guilty?
I would, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do, Your Honor.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding those rights?
None, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
None whatsoever, yes, sir.
Anybody threaten you or coerce you?
Not at all.
You're doing this voluntarily,
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
I am guilty, sir.
On the date of August 9th, 2022, at the location of Prospect Road near Berkshire Drive in Superior Township, Washington County, State of Michigan, did you have heroin in your possession?
I did, sir.
Had you used it?
Yes, sir.
And did you know what you were using was indeed heroin?
Yes, sir.
Sir, I do have to advise you that if I accept your plea, if there is misconduct committed by you as defined by the Michigan court rules between the date of this plea and the time of your sentencing, any plea agreements and or evaluations, the court would no longer be bound by. You would also not be eligible to set aside your plea. You understand that, sir?
Fully understand that, sir.
All right. Counsel, are there any other pleas, threats, or inducements that have caused this plea that have not been stated on the records?
No, Your Honor.
Have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
July 15th, 2025, at 10 a.m.
July 15th, 2025, time 10 a.m. before Judge Barr.
Thank you, Your Honor. And may I address bond?
What would the case be if you didn't? Go ahead.
Your Honor, so we did discuss this last week. I would just ask you to consider again a personal recognizance bond for Mr. Terry now that he has pled to a single misdemeanor. He does now have reliable transportation to court in the form of his mother and his own transportation. He has a job at Tradesman that he could go back to. Again, he did admit that he had a slip up with regards to his sobriety, but he is committed to doing better. He's provided proof that he was enrolled in medically assisted treatment as well as mental health services through Packard Health and CMH prior to going into custody. And he had already completed an access interview with Home of New Visions and had planned to enroll in intensive outpatient treatment again prior to the bond violation, and would plan to do that if released, if Your Honor again would consider a personal recognizance bond.
So there's no plan set up for what he's going to do at this point?
There is.
It's my understanding that he was approved to participate in intensive outpatient through Home of New Visions. He would just need to contact them after he is released.
Yes, sir.
Anything from the people?
Your Honor, Mr. Terry has been able to provide through his counsel a proof of the treatment that he's been undergoing since February or March of this year. So we would leave it up to the court's discretion since he is.
Well, I'll tell you what, I'm going to deny at this point, but the reason my understanding is you would be shortly seen by 1482's probation. And certainly that can be then addressed by Judge Barr as to his release. All right, consistent with what they see. So at this time, I'll deny your motion for bond modification. Bond will continue.
Thank you, Your Honor.
All right. Thank you, sir. Good luck to you.
Sure. Thank you.
Court calls the case People versus. Is it? You have Bash. No. What about, do you have Huffman? Court calls the case People versus Orby Huffman.
AP Richmond Deputy.
Your name, sir?
Orby Huffman.
It says Mr. Brown is the attorney.
Is represented by Mr. Burgess. Mr. Burgess is a substitute.
That is not what, when did that happen? This morning?
I want to tell you yesterday.
So where's Mr. Burgess?
He's not here.
Well, I have to say I didn't ask for adjournment, Your Honor.
New counsel coming in. All right. Sir, I don't have the public defender had to withdraw from your case. I don't know if they discussed that with you.
No, they did not.
Okay. The reasons, there's a conflict of interest. It looks like because of the public defender's representation or prior representation of the complaining witness in this case. Okay. So they would have to withdraw. They've withdrawn. The appointing authority has appointed Mr. David Burgess to represent you. Okay, we have not heard from Mr. Burgess this morning. Don't know where he is. Quite frankly, even if he appeared today, he probably wouldn't have everything to be able to and have talked to you to make an intelligent decision as to what to do with it. Okay. And so he'd likely asking for an adjournment anyway. So what I'm going to do, that's a long way of telling you, I'm going to adjourn your case out 1 week. Make sure Mr. Burgess has everything that he needs and then he has the opportunity to come talk to us. Okay? Probable cause conference will be adjourned 1 week to July 10th, 2025, 9 a.m. Bond will continue. Thank you, sir. Court calls the case People versus Tariq Wilson.
Morning, Your Honor. Andre Sabri requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Akiri Ekenroli.
Is this the only thing she gave you today?
It's a
What?
list,
Really?
Your Honor.
It's the only thing she gave you?
Yeah. So far.
She's just been wandering around back there like lost. And you didn't give her anything? Okay, fine. Anyway, your client's not here because he's not behaving himself and the facility would not sign in. Okay.
That's correct, Your Honor. At this time, we are requesting an adjournment for negotiation purposes.
Okay, very good. Probable conference will be adjourned to the 17th, 2025 at 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. One case, really, Chanel? One case. One case. Court recalls case People versus Thomas Basher.
Crossing go based on behalf of Mr. Thomas Vasher, who is present to my right, Your Honor. Mr. Vasher, can you state your name for the record one more time?
Thomas Bashan.
Standing is that the defendant will be pleading guilty to count 2, the receipt and concealment of stolen property less than 200, which is a misdemeanor punishable by up to 93 days in jail. Upon a successful plea to that charge, count 1 would be dismissed.
That is the correct reflection, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Thomas Bashan.
Sir, it is this court's understanding that you are going to be pleading guilty or no contest to the charge. Is that this report? No contest to the charge of receipt and concealment of stolen property less than $200.
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it. I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest this charge.
Yes, Your Honor.
Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty.
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights? Look at paragraph 5. You say Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Not that I know.
No.
Not that I
No. Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will.
Yes, Your Honor.
All right. Court has been handed and has been provided and has reviewed Washington County Sheriff's Office report for their case number 255214. Any objection to the court having reviewed that report?
No, no objections, Your Honor.
Sir, I do have to advise you that any sentence evaluation and or agreement regarding your case, if you were to commit misconduct from the time I accept your plea to the time of your sentencing, that the court would not be bound by that. You understand that?
Yes, Your Honor.
You understand also that if you commit that misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
You understand that, sir? All right. Counsel, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Is counsel aware of any other promises, threats, or inducements which caused this plea?
None, Your Honor.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
The defense is satisfied as well, Your Honor.
Court will accept the defendant's plea of no contest to this charge. To count two, count one is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be
At 10 a.m.
July 31st, 2025, 10 a.m. That is before Judge Washington.
Here, may I address bond when appropriate?
If you want to, go ahead.
Your Honor, now that my client has dealt with this case, the only other case that we'd be holding him is a driving without a license case out of
what?
Now that my client has dealt with this plea and the felony was dismissed, my client is asking to be released on a PR bond. The only other case that he has currently is a license case out of 14B.
And I would already given that would be reduced to the PR bond. If I
Yes.
was reinstated.
Response?
Your Honor, given that the felony is now gone, I don't necessarily object to the court reconsidering bond. However, I would you have three pending board requests, one for fleeing third OUND in March, RNO in April of this year, and a enforcement in the building from May of this year. At the time of this offense, the defendant was in abscond status from circuit court probation.
Your Honor, my client asked that he once again be given a PR bond. If the court deems it appropriate, he can go on a tether. He has no issue doing that. He just wants to get out, hopefully get back to his job. His girlfriend was here for support, but she had.
Basher, it really is not helping your cause to sit there and try to mouth anything to me. All right, because I'm trying to listen to your attorney and not pay attention to you.
Yes, Your Honor.
He does have some support here. She was here in the court waiting for him for about 3 hours, but she had to leave. As I said, Your Honor, the only other matter that would be holding him is a driving case. And these other charges that are pending have been pending for a long time. We haven't gotten anything. So
Are those going to be coming forth anytime soon or what?
I mean, the APAs who are assigned to those warrants aware and they look very chargeable to me, Your Honor.
Also, Your Honor, my client has been in custody for 45 days now.
All right, I will grant the defendant's motion to modify his bond. I'll set his bond at a $10,000 personal or cognizant bond. Defendant may be released on a GPS tracking tether prior, or can be released only with the GPS tracking tether in place, location tracking.
Understood, Your Honor. Thank you.
Thank you. Court does call the case People versus Virgil Dunlap.
Andrew Jones appearing on behalf of the people.
Edward Drukes for Virgil Dunlap. Your Honor, please state your name.
Virgil Dunlap, and you know.
I was appointed yesterday. I obtained the written discovery. There's some outstanding video discovery that I'm gonna ask for an adjournment to obtain.
Probable cause conference will be adjourned July 17, 2025, 9 a.m. Bond continued. Court does call the case People versus Elton Bell.
Zach report on behalf of the people.
Cameron Dadzish on behalf of Mr. Bell. Your Honor.
Wow, it's been like 2 hours now since I go ahead. I'll let you go.
He's answering my phone calls. He said his ride is just not answering his phone. I would like to ask for an adjournment. He literally was going to come here, make a payment for his.
You want me to send a car for him?
I can help him with that next time. He doesn't have transportation. He's relying on people who used to work for him in the past to get here. I'm even inclined to have him learn Zoom so he's able to attend, so we don't have to worry about this in the future. I don't believe he's ever not appeared before, based on my notes.
You don't know.
So we are going to be asking for an adjournment, Your Honor.
Response from the people.
Your Honor, this is a larceny case where the defendant took a check from the victim for $2,000 and for over a year to follow around to do the work. Oh, I'll pay you back, sort of thing. And here he is supposed to show up and pay some money for a misdemeanor offer, and he doesn't have a ride. We haven't seen photographic proof of him not having a ride. So
I don't know what that photographic proof of somebody not having a ride would be.
Well,
Be sitting in my house.
He suggested it.
I don't know. It's a running joke.
Yes, that was.
And Your Honor, he is 65. He receives quite little Social Security. He doesn't work. He has injuries. We're trying to provide. He was going to come with documentation of his injuries.
Are you on the docket next week?
I should be.
Okay. So what I'll do is I'll adjourn it out a week. If he doesn't show up, then I take you into custody.
I'm okay with that.
You're okay?
Yeah. Thank you, Your Honor.
Good.
She is good.
Sounds like she is?
Yeah.
Oh, yeah. He's just like, yeah, she'll be.
Now she's gonna, even if we're off, I'll be here.
Probable cause conference, July 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Mr. Dish didn't seem to care, did he? Court does call the case of People versus MBE Ind.
Good afternoon, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good afternoon, Your Honor. Assistant Public Defender Costin Valdez on behalf of Mr. Bayan, who's present to my right. Can you state your full name for the record, please?
Bayan.
Your Honor, we're going to be requesting about a month adjournment. There is negotiations going on between the AAG's office and I. My client just needs some time. He is going to be contacting friend of the court to get it, hopefully maybe a readjustment due to a change in circumstances. So we just want to give him time to do that, as well as make a payment so he can avail himself of the offer. So we're asking for about a month adjournment, Your Honor.
Any objection from the people?
No objection, Your Honor.
Turn the matter to August 7th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you, sir. Court calls the case of the People versus Dell Young Senior.
Good afternoon, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Young, who's approaching, Judge.
All right, what are we doing?
Your Honor, last time, if the court recalls, this was at exam stage and was adjourned to see if we could resolve it. I have reached out. I've spoken with the Assistant Attorney General. I don't think he's a person who may be able to approve or a deviation from what I think the standard resolution is. I guess we could reset it, but I think it might be more prudent to adjourn this probable cause so I can have a conversation with that person. And I think given the week that it was set, I think that person's on vacation.
Who's on vacation?
I think the Attorney General who was here last time, I believe she's out this week.
I believe Ms.
Adjourn
Messer.
it to,
Yeah, sorry, Judge, go ahead.
no, it's okay. I'll adjourn it to July 17th, 2025.
Thank you. I do have a green sheet.
9 a.m.
Thank you, Judge.
Yes, sir. July 17th.
Thank you very much, Your Honor.
Thank you.
Court calls the case of the People versus Dominic Kelly Payne.
Your Honor, Alexis Pluma appearing on behalf of Mr. Kelly Payne, who is present over Zoom. Sir, could you just state your full name?
Dominic Kelly Payne.
Thank you. And Your Honor, I do have a green sheet here. We are requesting a 2-week adjournment for plea negotiation purposes.
You guys should be doing these plea negotiations before you get in there, quite frankly. I will adjourn this out July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Montez King.
Good afternoon.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. King, who should be appearing via Zoom.
I'm here.
Mr. King, state your name.
Montez King.
You got him.
Yes, Your Honor. At this time, we'll be requesting a brief adjournment. There's still some potential outstanding discovery from a search warrant from June of last year. The detective whom APA really being reached out to about this is out on vacation this week, should be returning next week. So he's want to make one more confirmation before setting this matter for a preliminary exam.
You don't have an objection to the adjournment, I just did indicate to council that the search warrant return could take time. I don't know when it will be back, so I don't want to give the illusion that this.
You're gonna have it.
Yep.
I was gonna ask that question myself. Why don't I?
Yes, that was understood, Your Honor, but just before we set this matter, my client would like to see.
Pardon?
I said that was understood, Your Honor.
July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Your Honor.
Thank you. Court calls the case of the People versus Sheldon Lewis.
Can you repeat this for the people? Oh. Please, I retract that statement, sir.
Evan Artery requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of AP Rachel McDuffie, Your Honor.
Permission to practice is granted.
Evan Artery for the people.
Student Attorney Kara Rosengren on behalf of Mr. Sheldon, Your Honor.
Yes.
Can you state your name for the record?
Yes, Sheldon Lewis.
Sheldon, I didn't bring my whole pants. Lewis. All right,
Yeah.
go ahead.
Your Honor, we're respectfully requesting that the court set this matter for an exam.
Discovery is complete.
Yes, to my knowledge, Your Honor.
People have their witnesses available the 15th.
Try our best, Your Honor.
Preliminary examination will be set July 15th, 2025, 9 a.m. That is before Judge Moore.
July
15th. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Derek Mark.
That is for the people.
Stephanie Cannon on behalf of Mr. Martin, who's appearing to my right. Mr. Martin, could you please state your name for the record?
Derek Martin.
Your Honor, we are going to ask for an adjournment. Maybe you should have. Do you have a green sheet?
Excuse me?
Do you already have the green sheet, Your Honor? There's a green sheet for you, Your Honor, regarding that request for an adjournment.
In her hand.
We're just looking for.
Why is she asking me if I had it? Why? No, you had the thing. Why did you ask me if I had it?
You're right, Your Honor. I don't know what I was thinking. Your Honor, we're just looking for some discovery. The prosecutor's office has let me know that they are working on getting it for me.
Your Honor, it is ready to get picked up at this time and required a hard disk, so it's now actually ready for it.
Probable cause conference to adjourn July 17, 2020. 9 a.m.
July 17th.
What time?
Bond continued.
I'll call you.
You had a green sheet? The one I have, no, don't even try it. She was trying to catch me up.
Court calls the case, People versus Kaida Matson.
Good afternoon, Your Honor. Assistant Public Defender Chinazi Carey, I can ruling on behalf of, but unfortunately not with Ms. Kaida Matson.
What happened?
I don't know, Judge. We have not been able to make any contact with Ms. Matson, and we don't have an explanation to the court for her failure to appear today.
Might it be the bond violation?
I thought about that. I did. Very possible, but I don't know, Judge. Yeah.
This is your first case you.
It's
Spectacular.
Good job.
Thank you, Judge.
Bench or issue for defendant's failure to appear on $25,000 cash surety. That warrant will issue immediately. It already has a no bond. Oh, that's right, because then I'll continue the no bond. Court calls the case, People versus Kevin McCullough. McCullough, I think is.
Good afternoon, Your Honor. Assistant Public Defender Cosimo Bissi. On behalf. No, my trauma is over. I'm good.
I'm glad it worked out.
On behalf of Mr. McCullough, but not with Mr. McCullough, Your Honor. The word I received from him is that he checked himself into rehab this morning.
Pardon?
The word I received from him is that he checked himself into rehab this morning. I still haven't received the proof. I don't know, maybe he's still on the bus on his way there. So.
Amy advisor on behalf of people who request a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be setting him at $10,000 cash.
Yeah, I think he has a no.
He already has
bond
one.
from Community Corrections.
Oh, he's got a CC. Okay.
Yes, sir.
25,000 cash surety.
Thank you, Your Honor.
Probably only one.
25,000.
Yes. Court calls the case of the People versus Mikesha Malfoy.
Alexis Plumey appearing on behalf of Miss Malcor. And ma'am, could you just state your full name for me?
Mikesha Melcher.
Thank you. And Your Honor, we are requesting an adjournment today. We have just provided the people with some new information that they will need to review to see if we can work out a misdemeanor offer.
Probable cause conference will be adjourned to July 22nd, 2025. 9 a.m.
court. Your Honor, I have court July 22nd in Taylor.
I'll make it the 17th. July
Thank
17th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Thank you.
Thank you, ma'am. Court calls case People versus Vanish Mitchell.
District Attorney Kara Rosengren on behalf of. Ms. Mitchell, could you state your name for the court?
Lanish Mitchell.
Your Honor, we're going to be requesting an adjournment in this matter as we're still awaiting video discovery.
Probable cause July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Case of the People versus Keith Moore.
Hello? I mean,
Hello,
good morning, Your Honor.
good afternoon, sir.
And Alex Warren Green on behalf of Mr. Moore. Mr. Moore, can you state your name if you haven't already?
Keith Moore. Keith Jarrett Moore.
Thank you, Mr. Moore. Your Honor, today's date and time for probable cause conference. At this time, I am going to ask the court to set a competency hearing. I have prepared a proposed order.
For a forensic evaluation.
That is correct, Your Honor.
Forensic evaluation be ordered. I'll set a comp hearing mid-90, please.
Oh, October 2nd.
Set a competency hearing for October 2nd, 2025, 9 a.m.
Yes, Your Honor.
Thank you. Bond will continue. Court calls case People versus Megan Moses.
Christina Rivera for the people.
Marshall Feaster, first assistant public defender on behalf of Miss Moses, who should be on Zoom, Your Honor.
I'm here.
I need a camera, ma'am. Oh, thank you. State your name, please.
Megan Moses.
All right, go ahead.
Thank you, Judge. I did speak to Mr. Ward about the file. He did show me a receipt for about $827 of restitution. Miss Moses has to pay that in order to have this matter reduced. So we're asking for about 4 weeks. So you can try and get that $827 paid and then resolve this with a misdemeanor resolution.
She paying it?
Yeah. And then I'm going to ask you if we can change the bond to add it as so she could pay the court, to make it a bond payable to the court.
Do what?
I don't know what the term is. Isn't it the court makes it into a bond, and then I believe she can pay you the $827.
Listening to you is causing me trauma.
I apologize, Judge. This is my first case of the day. I'm still.
I know.
I'm still
I
getting
was
more.
fine up until this
No,
point.
sorry, man. It's been a rough day. We apologize.
Defendant, modify your bond. Defendant may pay into court. How much was the?
$827.
$827 to be held for restitution.
That's what I was asking for, Judge. Thank you.
I'll adjourn probable cause conference into August 7th.
You understand that, Miss Moses? Can she hear us?
She didn't hear any of that.
No.
Miss Moses? Oh. Oh, she's back. Hello? Were you able to hear any of that, ma'am?
It cut out a little bit. I didn't hear much. Sorry.
All right. You're allowed to pay the $827 into court as bond to be held for payment of the restitution. Okay? You have to pay that at the 14B District Court in Ypsilanti Township.
Okay.
Okay? I'm adjourning your proceeding out to August 7th, 2025 at 9 a.m.
Okay. So do I have to have that fully paid by then, or I guess what is the?
As you spoke to Miss Carrie, I really on the phone. We need this paid as soon as possible. So we'd like you to try and get it paid by that date, so we can get this matter resolved and closed out for you.
Okay. And then the tether as well, will that be able to be removed?
It will not today.
Okay?
Okay.
Thank you,
All
Judge.
right, thank you.
27.
Court does call the case. People of the state of Michigan versus Rodney Napier.
Yeah, Richard McDuffie for the people.
Constable Basie, on behalf of Mr. Napier, but not with Mr. Napier, Your Honor.
Hold for one moment. And what do we do?
Your Honor, I would be asking for an adjournment. I have not had contact with my client. So something needs to be done about these buses, Your Honor. They're causing me trauma.
Bench warrant will issue for defendant's failure to appear. Bond is any amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls the case People versus Nicole Nelson.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of, but unfortunately, not with Mr. Nicole Nelson.
It's two cases.
I know. I know.
Do you have a client on either one?
They just don't like me today. No. They're not the-
So this is number two.
Maybe they're number two, Judge.
They might be all on the same bus.
It's possible. Right.
Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of 10,000. Cash surety. That warrant will issue immediately.
Keep that. I almost got stuck in here.
Court calls the case of the People versus Antoine Patterson.
Good afternoon, Your Honor.
Ready, Judge. Portia, please still have Mr. Patterson. Please state your name for the record, sir.
Antoine Patterson.
He
Senior.
apologizes for not having on pants. Mr. Bellinger did not tell him he had to wear pants, so.
Oh, yes. Oh my God. Oh my God. Oh, and it's laundry day, I promise. Like, I missed when I was supposed to go to Hope Clinic, and I had missed that when it was like 98 outside, and I was supposed to go to Hope Clinic yesterday. Well, I don't remember the day, but we rescheduled it for Monday, and I got like 4 big bags of clothes, and I actually wore these already, and I don't even got my right belt. Like,
He
he
apologizes, Judge, for not having
to the
on pants.
deepest of depths of my apology. I apologize. Sorry. What's that?
There's a lot more information I need.
He does have colorful socks, Judge.
What?
He does have nice colorful socks, though.
You picked those out on purpose. No, I'm kidding.
So
I get it.
The court should have 2 things in the file, Your Honor. If the court's willing to do a plea, we have a plea and advice of rights in the form. If it arrives too late, we also have a green sheet for an adjournment, Your Honor. So whatever the court's pleasure.
Why would you be too late in the form?
Okay.
It's not going to be a no contest plea.
No, Judge. All right.
So it'd be pleading, what the plea form indicates is that it's pleading guilty to domestic violence.
Yes.
That being count 2. Count 1, the child abuse, 3rd would be dismissed. There is, the defendant is agreeing, and actually also prosecutor and defendant. Yeah. So it's actually check both 3 and 4 that they're agreeing to 7694A, 2 years probation. The offer is contingent on the defendant having no assaultive contact with the minor victim or anyone else since the incident date for the case. Defendant not to have contact with any minor children other than his biological children. Oh, so that's the CPS recommendation. The only part of this that I want to make sure the court's understanding is that I read that to mean that if there is a accusation that comes up that is not known at this point?
Slight amount of detail, Your Honor. So there has been allegations, and I know both sides have tried very diligently to figure out what those are specifically. And we're just not getting enough information. So in the interest of moving this forward, we've adjourned quite a few times. It's contingent on, if I receive information or anyone receives information that the victim has been harmed in any way by the defendant since the incident that underlies this case, then that changes everything. We would withdraw the offer, and of course, you know, the plea would then be void essentially, and we'd be back here.
That you're understanding.
That is what Mr. Bellinger negotiated, yes, Judge.
Wow. Okay. I have him sworn.
Right hand. Do you solemnly swear to affirm the testimony about to give the true self you got?
Yes.
State your name.
Antoine Patterson Senior.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of domestic violence. Is that correct?
Yes, sir.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. You understand also, sir. Why are they forgetting this?
Oh, this check.
I just checked.
Oh.
And I want to make sure he understands. So.
Okay. Yes. So he won't be the one who does this.
So you understand that while I'm taking your plea, I would not be your sentencing judge in this matter. You understand that, sir?
Yes, sir.
That you would be sentenced before Judge Washington.
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead guilty?
Is it okay to ask a question?
Sure.
Okay, so when you say sentencing, I get to the sentencing court date, the 2-year probation thing and the 4A, that's when I do my probation, I'm off, like, just, I don't have to try to get it expunged, correct?
Well, I think what he's asking is if he successfully completes his probation under 4A, will this be removed from his record per the statute?
And the probation is what I'm going under. So when I get to the sentencing, he's just gonna sentence is it like for a short 2 years probation, or can it be up to 2 years?
The way I read this plea agreement is that you're agreeing to 2 years probation.
Okay, yeah, that's fine with me.
Okay.
Just wanted to clear the BS. I still want to plead guilty.
You still want to plead guilty?
Yes, sir.
All right. You have any other questions?
No, sir.
All right. To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form?
Yes,
Is that correct?
I believe so.
Any
Yeah.
question regarding those rights?
No, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to place?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
All right. On the date, did you wish to voir dire or you want me to write?
I will prefer you to, Your Honor.
Okay, no, that's fine. That's fine. I just didn't know in terms of specifics. On July 8th, 2000, between the dates of July 8th, 2024 and July 9th, 2024, at the location of 2871 Binding Drive, apartment 308 in Ypsilanti Township, Washtenaw County, state of Michigan. What did you do that makes you think that you're guilty of this offense?
I had a lapse of emotions and made an erratic decision on impulse of high concern.
And what did you do?
I hit a kid and I hit him. I gave him what I feel was a whooping.
Was this child in your household?
Yes, sir.
All right. And so that you had that relationship with the child that you live together?
Yes.
All right. And I'm a little bit concerned as to, you intentionally did the acts to this child that, as you say, constitute a whooping.
Say that, I'm sorry, say that again, please.
The acts that you did intentionally.
Intentionally, no, I don't want to say, like, I didn't intend to, you know what I'm saying?
Okay.
Can I help
I'll stop you right there? Because, go ahead.
Thank you. What Judge is asking you, I think you had this conversation with Mr. Bellinger before he left, was you had a relationship with this child that lived in the home with you.
Mm-hmm.
And that's a yes?
Yes.
Okay. And you proceeded to hit that child.
Yes.
And you knew what you were doing.
Well, yeah, I mean, pretty much yes. So yes.
Well, pretty much yes, or
yes.
So you knew what you were doing, and you whooped that child, correct?
Yes.
And that could be considered by some, the court, the prosecutor, an excess of what was appropriate.
Yes.
That's a yes?
Yes.
If the court wants to adjourn for Mr. Bellinger to have more conversations?
I think I'm going to. I'm not going to accept his plea. I'm a little bit concerned.
Okay.
Based on what you said. Pardon?
I'm sorry. I spoke out of turn.
No, go ahead.
Okay, so this has been going on for a while. I'm trying to get the sentence under it because when I went to Michigan Works to try to get into the electrician.
Okay, listen to me, sir. The problem is, and I understand you may be wanting to move this along, the prosecutor wants to move it, everybody wants to move it along. The difficulty is, for me, is I have to be assured and convinced that you're voluntarily pleading on this, number one, and that what you are telling me you did would constitute this crime.
Okay.
All right. Because of the way that you answered some of the questions. I'm not saying it's answered wrong. I'm just saying these are my concerns. Because of the way that you answered the questions, also because of some of the things and hesitation that you had in response to questions, I have some concerns as to whether or not you believe that you may be guilty of this offense. And so, for your protection, as well as the protection of the plea and the integrity of the plea, I'm going to adjourn this. I'm not going to accept your plea today. I'm going to adjourn this out and allow you to speak with counsel.
Okay.
Some additional time. All right?
All right. Thank you, sir. I appreciate it.
And what I will do then is I will adjourn this to the 17th.
Thank you, Judge.
At 9. On continue.
Thank you, Judge.
Court does call the case of the people versus Paris Pope.
Attorney for the people.
Stephanie Cannon, on behalf of Ms. Pope. Ms. Pope, when you're at the lectern, please state your name for the record. Paris Pope. And Your Honor, we would be asking for this to be set for a preliminary exam.
Is discovery complete?
No. But Your Honor, it's not discovery that we need for the preliminary exam. I have requested it. I believe they would likely have it to me before the preliminary. Exam.
What is it? Because
the best footage. I just don't have the best footage.
The body cam footage?
Yes, that is correct.
Your Honor, if I may, I'm sorry, Kevin. When I looked at this file, I saw that it was a brand new case, and as far as I could see the other day, we didn't actually have any discovery turned over to the PD's office. If Ms. Cannon has received some of that in part in the last 24 hours or so, that's fine, but I would think.
I have the police report, I have the information, the only thing I don't have is the body cam footage, to my knowledge.
Okay. I'll defer to the court and Ms. Cannon if they're still.
I've let my client know this. My client is asking for a preliminary exam. I've explained to her that the court will not adjourn it for that reason if we don't have it.
Correct.
And she is trying to move forward, Your Honor.
And ma'am, so that you understand, if something appears on that body cam footage that's beneficial to the people and they intend on introducing it, I'm not going to hear any objection from your counsel that you haven't had the opportunity to see it.
Okay.
And adjourn that. You understand that?
Yes.
People have their witnesses available the 15th.
Try that, sir.
July 15th.
Preliminary examination in person, July 15th, 2025, 9 a.m. That's before Judge Washington.
Thank you.
Thank you.
Thank you so much, Your Honor.
Thank you. Court calls the case of People State of Michigan versus John Riggs.
Zachary Ward on behalf of the people.
And Alex Warren Green on behalf of Mr. Riggs. Mr. Riggs, can you state your name for the court?
John Riggs.
Your Honor, today's date and time for probable cause conference. At this time, we're asking for an adjournment. I've completed a green sheet here. We want Mr. Riggs to speak with a social worker and at least begin a mitigation report. Thank you.
You've seen the community corrections progress report?
I have, Your Honor. I reviewed that with Mr. Riggs. Your Honor, I see that he was late on the June 29th test, at which point he returned an alcohol detection of 0.006. Of course, I reminded him to be on time and of course not drink. He is in sobriety court while he's in the felony recovery court. I think he has a strong support system, but as the report reflects, my client does deny consuming alcohol.
Did he take a retest on that?
I'm not sure, Your Honor. I think if this is going to be treated as a violation, I would be asking for a hearing and the long form SoberLink report so that we can see any potential retests. And so we can have that looked at by a PBT expert.
So I'll set a bond by hearing as well as the adjournment of the probable cause conference. Set that out to the 17th, 2025. And actually, that's going to be at a 3 p.m. block because we'll have bond violation here. Bond will continue at this time.
Thank you, Your Honor, and a probable cause conference at the same time.
Yes.
Thank you.
You'll just be in the 3 o'clock block, and that is in person, and not appear to be sent.
Got it. Thank you, Judge.
Court does call the case People versus Terrell Stevens.
Mike Gaddy, Assistant Defender on behalf of Mr. Stevens, who is here present by Zoom, Judge.
Yes.
Judge, we'd like to set this matter for an exam.
All discoveries complete.
I reviewed it. It looks complete, Judge.
You will have the witnesses available the 15th. Preliminary examination will be set July 15th, 2025, 9 a.m. That is before Judge Moore. In person.
Thank you.
Thank you.
Okay, thank you.
Thank you. Court calls case People versus Colin Vanderbude.
Assistant Public Defender Hannah Appleton on behalf of Mr. Vandermeer, who should be appearing via Zoom from treatment. There he is.
Oh, there he is.
Mr. Vandermeer, will you state your name for the record?
Colin Vandermeer.
Thank you. Your Honor, I do have a green sheet. We're asking for an adjournment. Mr. Vandermeer is still awaiting treatment at the forensic center. He was found incompetent but restorable in November.
Right.
I did send an email to the CFP to see if we could get an update, but I don't have a response.
So he's waiting to get himself enrolled in treatment.
Yes, at the forensic center. That was.
Yes, at the hospital.
This is a reset of the review. Hearing
Yes.
is that what it is? Okay. Got remarked. All right. Just bring him back and forth. Why don't I set it for September 25th?
Okay.
And then that way, if we get some updated information, we'll figure it out before then, but we'll just do that. Defendant's bond will continue. Okay,
Your Honor.
thank you, sir.
Mr. Vandermute, your next court date September 25th. If you have any questions, give our office a call, okay?
Oh, yes, ma'am, sorry.
Thank you.
Court calls the case People versus Tyrell Alex. Is it Gassara?
Terrell Welch, Jalisa.
And Assistant Public Defender, not to carry action really, Your Honor, on behalf of Mr. Vox Gassara.
Well, you had a client show up.
My client is here, Judge. That's right. Your Honor, we are ready. The people sent over a plea form to us on yesterday. Unfortunately, we weren't able to get everything into the court by the deadline, so we do have a resolution. We're asking for a brief adjournment, whatever the court deems sufficient to review the document.
Everything you think is resolved?
Yes, Judge.
No, but I'll put it over to the 10th.
Okay.
2025. Just put it out a week. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, sir. Court calls the case of the People versus Zachary Brown.
For Douglas for the people.
Afternoon, Your Honor. Dan Garrett on behalf of Mr. Brown. He's here by Zoom.
Yes.
Good evening, Your Honor. I'm Zach Brown.
All right, and good afternoon. All right, what do we do?
Your Honor, there should be a green sheet in Your Honor's file asking for an adjournment for further negotiations.
How much time do you think you need?
2 or 3 weeks, Your Honor, would be perfect.
I've got the 17th or 22nd.
17th, please, Your Honor.
17th. Probable cause conference will be adjourned July 17th, 2020. 9 a.m. Bond continued.
Thank you very much, sir.
Thank you, Mr. Brown. Is that it for you, Mr. Kim?
No, Your Honor.
All right. Can you just approach on a second?
Yes.
Court does call the case People versus Bryn Delorme.
And good afternoon again, Your Honor. Dan Garrett on behalf of Bryn Delorme. Bryn, can you identify yourself, please? She's muted.
Hi, can you hear me?
Yes.
Oh, okay. Hello, Your Honor. This is Bryn Delorme.
Okay. I have before me a plea form. Is that what we're doing?
It is, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of operating while visibly impaired. The 93-day offense upon their successful plea. That charge, count 1, would be dismissed. That is the court's full understanding of it.
Count 1 and 2.
Yes, counts 1 and 2 will be dismissed. It was further down. Got it.
That's our understanding as well, Your Honor.
All right, very good. Ma'am, could you please, you usually said you've got one for me. Thank you, sir. Ma'am, could you please raise your right hand?
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
My name is Bryn Delorme.
All right, you can put your hand down.
Okay.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor, punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes, Your Honor.
All right. Court further has to advise you that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the Judge Freshour in the 14A3 District Court. You understand that, ma'am?
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I'll plead guilty, Your Honor.
All right. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor. I have it here in front of me.
All right. Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of April 22nd, 2018, at the location of westbound I-94 in Scioto Township, Washington County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed or ingested intoxicating liquor?
Yes, Your Honor.
Do you recall what you had and how much?
I believe I had a few glasses of wine earlier that evening, but it would have been the previous day, the 21st.
All right. Were you stopped by the police
Yes, Your Honor.
or was there an accident?
I was stopped by the police. They introduced themselves as peace officers. There were 2 of them. Yes, Your Honor.
Do you know why they stopped you?
They said failure to stay in my lane.
All right. You're not disputing the right of the police to stop you in this instance, are you?
No, Your Honor.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood draw?
Yes, Your Honor.
All right. Do you recall what the results of that blood draw were?
They didn't share them with me at the time. I just learned about them recently.
Your Honor, we'll stipulate for the plea was a 0.103 blood result.
0.103 blood.
Correct.
All right. Thank you. Ma'am, do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle is visibly impaired due to your consumption of alcohol?
I'm sorry, could you restate that, please?
Sure.
Thank you.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
Ma'am, I do have to advise you that if I accept your plea, there is no recommendation or evaluation. But however, if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, that any evaluation or recommendation, the court would not be bound by. You understand that?
Yes, Your Honor.
And you also understand that if you did that, you would not be permitted to withdraw your plea.
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements that have caused this plea to occur?
No, Your Honor.
Has the court complied with the court ruling? Would it be proper to accept this defendant?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will occur
September 22nd, 2025 at 9 a.m.
September 22nd.
Yes.
Okay. September 22nd, 2025, 9 a.m. before Judge Freshour. Bond will continue.
Thank you very much, Your Honor.
Thank you. Thank you, ma'am.
Thank you, Your Honor.
Court calls the case of the people versus Dean Keeney.
Good afternoon, Your Honor. Advisor, on behalf of the people.
Good afternoon, Your Honor. Dan Garrett on behalf of Dean Kuhn.
My name is Dean Kuhn, Your Honor.
Your Honor, I'm asking for an examination on this matter.
All right. All discovery is complete.
I believe it is, Your Honor.
All right. People have their witnesses available to 15.
You said another case with a victim of the case. Could we have the next available date of Mr. Young?
I can't. Can we possible keep it on the 15th? Otherwise, I'm going out pretty far.
The 15th.
Thank you, Ms. Roger.
Preliminary examination, July 15th, 2025, 9 a.m. That is before Judge Washington. It is in person. Bond will, with its conditions, will continue.
Thank you very much, Your Honor.
Court does call the case People versus Jose Montalvo.
Afternoon, Your Honor. Dan Garrett on behalf of Mr. Montalvo. I see him on Zoom. Jose, can you identify yourself?
Jose Montalvo.
Thank you.
Your Honor, he's been accepted into the drug court, so there'll be a straight waiver today.
Okay, straight waiver. Sir, you're waiving your right to a preliminary examination?
Correct, Your Honor.
You understand that that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. Do you understand that?
I understand, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Correct, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we'll waive reading of that single count. Stand mute, please.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
September 26, 2020. Oh, August 26, 2025 at 1:30 with Judge Humphrey.
August 26, 2025, 1:30, Judge Cook. Bond will continue with its conditions. Thank you.
Thank you very much, Your Honor.
Thank you, Your Honor.
Is that it for the Garrett? Is that all right?
Nice work, John.
Court does call the case People versus James Chandler.
Good afternoon, Your Honor. We please this honorable court, Brandon Bird on behalf of James Chandler wearing pants today, Your Honor.
Well, see, we all learn, don't we?
Mr. Chandler, please state your full name for the record.
James Chandler.
You promised me you wouldn't come back that way, so you're it. You're it. All right. What are we doing?
Respectfully, we'd like to set this matter for exam, Your Honor.
Your Honor, if I may, I believe Ms. Sanda sent the amended information to the court and defense counsel. I want to make sure.
I have
Both are understated. I do have that here.
I don't believe I have it.
Today?
Yes, today.
There's an amended complaint adding.
And Your Honor, well, it's a change really. It's a domestic violence second offense as opposed to the first offense.
Got it.
So what I can do, counsel indicated to me that he doesn't have it. I can have it printed and counsel report.
Good. Hold on. I never had so much. Miss Tanner, don't worry about, can you? I can print another copy. We'll print another copy and get it to council. All right. Would you, to the extent that, actually, I don't know that he needs to, but you would acknowledge the second offense notice in the amendment?
I acknowledge the offense notice.
All right. And just so that, well, so she, actually, you waived the reading on count 3. Here's the way, because here's how it had to be done so that we're clear. Counts 1 and 2 existed. They couldn't just add the second offense notice. I guess they could theoretically, but I don't think so. So count 3 is then added as the domestic violence second offense.
Okay, Your Honor, waive the reading, stand.
All right. Your client would stand mute, so I'll indicate that he was arraigned on count 3. And so if I set this for exam, is that what you want, sir?
Yes, please, Your Honor.
And so all discovery is complete?
Correct, Your Honor.
All right. And would the people have their witnesses available on the 15th? All right. Preliminary examination in person, July 15th, 2025, 9 a.m. before Judge Moore.
Gonna be here.
Bond will continue with its conditions.
Thank you, Your Honor.
So we'll get that right to you, Counsel.
Thank you, Counsel.
Thank you. Court does call the case People versus Leon McEwen.
And for those for the people?
And yes, Your Honor, Brandon Bird on behalf of Leon McEwen. Mr. McEwen, can you please step to the podium?
Oh, there
State your full name for the record.
Yeah, McEwen.
Thank you, sir. What are we doing?
I'd like to,
For an adjournment.
no, Your Honor, we'd like to set this matter for exam.
Okay. Yes, sir. Discovery is complete.
It is, Your Honor.
People have their witnesses available to 15.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 15th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you.
Hang on a second. Is there a bond? I don't have. Is there one? Hang on a second. I don't know if we have a violation report.
I believe I received that today, Your Honor.
You did? I don't have. Anything you want to say regarding this violation?
First of all, we'd like to apologize to the court and the prosecution for making representations that my client was clean. I just received a report today and I was going off the indications of my client, in which he apologized to me. And he wants to apologize to this court.
Well, but here's I mean, I understand the apology, but he had, by telling you what he told you, he had you give certain representations to this court.
And believe me, we had a long discussion about that.
I'm sure you did.
We did. I believe my client maybe was embarrassed. I did, after discussing this with my client indicates to him that he did relapse. The stress of this case was helping him relapse, but he said one thing that really mattered. He said, it's not an excuse. And I understand that my client is taking accountability for this situation.
So he admits to this violation.
He admits to it, Your Honor.
All right, go ahead.
I believe my client takes accountability for this situation. He really came to me and said, I'm really trying to straighten out. He understands that he needs help straightening out. I understand that addiction is more of a disease, and I believe there's better ways that addiction could be handled besides being in the confines of the county jail. My client will take, he is trying to take conditions serious, Your Honor, but my client suffers from an addiction and he suffers from that disease. And he understands that he needs that help. And he actually indicates to me that he reached out and has been searching for help. He could tell you, I know Domino Farms was one of the places, correct?
Yes, sir.
And he was telling me other aspects, other avenues that he was looking at to get that help. We just asked that this court have leniency, and we're coming to beg your mercy on this matter, and ask that this court have leniency on my client, maybe even allow him in an inpatient treatment, Your Honor, instead of having them behind bars.
Anything from the people?
Your Honor, as the court may remember, yes, last time we were here, we were going to set it for exam, and I had put the offer on the record that it was that if Mr. McEwen provided proof that he had undergone some treatment since the date of this offense, that he offered that misdemeanor, and Mr. McEwen had interrupted and said he'd been in treatment for 5 years. Mr. Bird later, we adjourned, and Mr. Bird later came to me to tell me what the proof was, and while I respect that Mr. McEwen represents that he was for some time clean. I believe that he needs, gonna need some help from some sort of a program. And so I do not think at this time that he is able to comply with the bond conditions if he's not in a program.
Anything else, you want to say?
I respectfully honor, I'm asking if there's any way possible that my client, if he does go to jail today, could he be released to some sort of inpatient treatment?
I will always sign an order that allows him to be released to treatment, but what he's not going to do is come before this court, violate our bond conditions, then lie to counsel, have that lie then go to the court and think that somehow or another he's going to get over on the system. It doesn't work that way, and it certainly doesn't work that way with me. All right, because I know that if his circumstance, if he had told you the truth, Mr. Berg, you would have made sure to try to communicate in some way to this court. Not only just in terms of your ethical obligations, but also just in terms of trying to make sure that the right thing gets done, because that's the way that you are. So I think he's let down a whole lot of people, most of all himself. So at this time, certainly I will entertain anything, but is to go before Judge Washington on the 15th, but in the interim, defendant's bond is revoked. He's remanded. Court does call the case of the People versus Adrian Gearman.
Yes, Your Honor. Brandon Bird on behalf of Adrian German, standing in for Hassan Hamadi. Mr. German, can you please state your full name for the record?
Yes, Adrian German.
German. All right. And you have no objection to counsel standing in?
No, sir.
You're standing in for somebody?
Correct.
Yeah. You have no objection to that, sir?
No, no.
Okay, go ahead. All right. You're asking for an adjournment?
Yes, yes, Your Honor.
All right. PCC in this matter will be adjourned July 17th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
You and Your Honorable Court have a great day.
You do the same. Court calls case of the People versus Matthew Newton.
Jeremy Glick, Mr. Newton, who's standing to my right. Can you state your full name, please?
Matthew Newton. I have before me a plea form. Is that what we're doing today?
That's correct, Your Honor.
All right. Plea form indicates that the defendant would be pleading guilty to the charge of operating while intoxicated, second offense. That's the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That is the entirety of the court's understanding of the agreement.
Yes, Your Honor.
Please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Why does everybody state your name?
Matthew Newton.
Thank you. You can put your hand down. Why does everybody think they can wear shorts to court?
I shouldn't have.
What?
I said I shouldn't have. I don't know. I apologize.
You didn't tell him to do that, did you, Glenn?
I did know he was
asked-
wearing shorts. I apologize. I knew he was coming from work. I'm sorry, Your Honor. I will eat that one, but it won't
Really?
happen again.
How's that sort of feel in the middle of your chest falling on that? All right, anyway, all right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor, punishable by up to a $1,000 fine plus cost, up to 1 year in jail. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
I do.
And understanding that, then I should also advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that, sir?
I do.
All right. And understanding that, you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form, did you?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and also because you believe that you are indeed guilty of these offenses? Or
Yes.
this offense? February 22nd, 2025, at the location of South Ann Arbor Road near Pleasant Bridge, City of Saline, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consumed intoxicating liquor?
Yes.
What'd you have and how much?
I had 3 or 4 Captain and Cokes over 4 hours or so.
Were you stopped by the police or was there an accident?
I was stopped.
Why'd they stop you?
Failure to come to a complete stop at a stop sign.
All right. You're not challenging the right of the police to stop you, are you?
Nope.
All right. Were you ultimately arrested?
Yes.
Were you taken to a hospital for a blood draw?
No.
You were taken, was there an intoxicator done?
Yes, he was taken to the Saline Police Station where he.
And an intoxicator was done? What were the results of that?
At there is 0.100.
Do you have any reason to dispute those results?
No.
And had you previously been convicted on or about April 4th, 2003 in the 52nd District Court and or on or about May 29th, 2003 in the 48th District Court of operating while intoxicated?
Yes.
All right. I think we got everything there. All right. Is counsel aware of any other threats, inducements, any other inducements, pleas or promises? I'm sorry. Let me do that again. Any other promises, threats, or other inducements that have caused this plea?
No, Your Honor.
None known to the people. I would just make a note for the record that the court did issue a recent order to comply, but no, nothing affecting the plea.
Yes, we issued an order to comply because he had been missing some testing.
Yes, and I've discussed that with Mr. Newton and he understands the importance of complying. And I will add that he has voluntarily notified probation every time that there has been a late test and tested negative shortly thereafter.
All right. All right. Sir, I do have to advise you, and I don't think there is any sentence agreement or any evaluations that's been done, but if there has been, I would advise you that if you do commit misconduct as defined under the Michigan court rule, that the court would not be bound by any evaluation or sentence agreement. You understand that, sir?
Yes.
And further, you would not be entitled, if you commit that misconduct, to withdraw your plea. You understand that?
Yes.
Now, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
I'm satisfied, Your Honor.
Court will accept the defendant's plea. 2 counts, 2 count 1 is dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be
At 9 a.m. with Judge Freshour in Chelsea.
September 30th, 2025. What time?
9 a.m.
9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you.
Court does call the case of the People versus Mark Cochin.
Good afternoon, Your Honor. Thank you, Vice Mayor, on behalf of the people.
And good afternoon, Your Honor. I'm Shannon Smith on behalf of Mark Cochin. Mr. Cochin, can you please state your name for the judge?
Yes, Mark Cochin.
All right. Where we going?
Your Honor, at this time, we're asking the court if we could please adjourn today's PCC. We're asking for a longer adjournment because this is a case involving voluminous discovery. I just received some videos. We need to make sure they work. We discussed August 14th, if this court would allow that. I also have discovery I need to tender to the prosecutor's office because there's a long custody battle and CPS case that goes into the criminal charges in this case.
Gotcha.
One of those.
Yeah.
And no objection to the August 14th date of that. Is acceptable.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of People versus Willis Cherry.
David I. Goldstein appearing on behalf of the defendant.
Willis Cherry. Thank you. What are we doing?
Sitting for exam, Your Honor.
And Your Honor, as far as the date goes, would ask if you couldn't set it a little bit further out. The victim on this case is in the military. There was a co-defendant who's already gone to exam, and the victim was able to come on that day. The military was able to accommodate them. So I'm asking for a little bit more time so that we can arrange.
So there was already an exam held on the co-defendant.
I believe he ended up waiving, but the day of the exam, the victim was able to come. The military was able to accommodate him. So we're asking for it to be set a little bit out to try to accommodate getting him there.
I'm glad she clarified because it was my understanding he had waived. So when she said he held, I was getting a little surprised.
And I just wanted to know because if it was held that this one would go, I tried to put this before that same judge, but it was
Understood.
not held. So waiver.
Judge, I don't have any objection. I had already looked at the 15th and that was going to be a good day for me, but if she's not available, that's fine.
What, how long a period in time do you think you need to be able to arrange with the military to have them
Your
here?
Honor, if you give us a month, we'll try to see if we can get it done.
Okay, what about August 12th? Would that work?
It'll,
Your Honor, I've got two trials in front of Judge Conlon that are scheduled for Monday. One of them I think is going to be a plea, but the other one is probably going to go. I could do the 20th. I'm sorry, the 19th.
Would that work too? I don't have judges for that.
it is Judge Moore. Judge Moore.
I'm at noon on that. Oh, it's one of those days. Okay. Preliminary examination in this matter will be set on August 19th, 2025 at 9 a.m. before Judge Moore.
Judge Moore, Your Honor?
Yes, sir.
Thank you.
Bond will continue.
Wait for me.
Court does call the case People versus Antoine Pitts.
David I. Goldstein appearing on behalf of the defendant. Mr. Pitts, there's already a bench warrant for him, Your Honor.
Yeah, there is. He's not here.
No.
Yes, the community corrections bench warrant will continue.
Thank you.
Thank you.
Court does call the case People versus Julius Holst.
Yes. I don't do this for Julius.
Your name, sir?
Julius Hurst.
Thank you. Sorry about that. Are we doing the plea form?
Yeah, no contest plea. I do have an advice of rights signed from today.
All right. The plea form I have indicates that the defendant would be pleading no contest to the charge of attempted resisting and obstructing an officer. That is a 1-year misdemeanor. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of any.
That's correct. People, thank you, APA 10 and I blame Mr. Gold.
All right, may I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name.
I, Julius Host.
All right, sir, it is this court's understanding that you're gonna plead no contest to the charge of attempted resisting and obstructing. That is a misdemeanor punishable by up to 1 year incarceration of $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand what? No, you can put your hand down.
I'm
Raising it for me to call on you about.
I'm sorry.
You good?
Yes, sir.
Okay. All right. You also understand, do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it I have to make sure that you understand. And that is that it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The other thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in the 14A2 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea?
Civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest. Or guilty.
You're right.
Oh, which one you're
No
gonna?
contest. I'm sorry.
No contest?
Yes, sir.
All right. You understand that by pleading no contest, you'll not have trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, sir. No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
All right. The court has been handed and has reviewed Ypsilanti Police Department report for their case number 255809. Any objection to the court having reviewed that report?
None from the people.
All right.
No, Your Honor.
All right. Sir, I do have to advise you that if I do accept your plea, you understand that if you do commit misconduct as defined under the Michigan court rules prior to the time of your sentencing, that any sentence evaluation or recommendation the judge would not be bound by. You understand that, sir?
Yes, Your Honor.
And you also understand, sir, that you would also not be entitled to withdraw your plea if you commit that misconduct.
Yes, Your Honor.
All
I
right.
didn't understand it.
Is counsel aware of any other promises, threats, or inducements that resulted in this plea?
None from the people, Your Honor.
No, Your Honor.
All right. Have I complied with the court rule and would it be proper to accept this defendant's plea? Well, let me put it this way. Based upon a review of the report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Now, have I complied with the court rule and would it be proper to accept this defendant's plea?
Your Honor, I believe so, but if I could just confer with counsel for a quick second to make sure that we're both clear on one thing.
Sure.
It was just that.
Thank you, Your Honor. I think we're all
I
set.
believe that people are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be August 25th or August 13th, 2025. Time again? 10 a.m. before Judge Barr. Bond with its conditions will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Joseph Tripp.
And Edward Drunkowski on behalf of Mr. Trim.
How you doing, Your Honor? Joseph Trim.
Thank you.
Your Honor, at this time, I'm asking for an,
Pardon?
if we're asking for an exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 15. Preliminary examination in person will be July 15, 2025. 9 a.m. before Judge Moore. Bond will continue. Thank you. Thank you, sir. Court calls the case. People versus Aaron Fromm. Oh, he's here. Both in Zoom. Okay, counsel, I can't hear a word you're saying.
Is it better now?
Oh, we could say something again.
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Yep, we got you now. Okay. All right.
Your Honor, I was going to say that defense counsel brought to my attention that Mr. Fromm actually had a case in Wayne County that covers the same allegations. And so I'll be filing a nolle prosecution in this case.
All right. Any objection to that?
No objection, Your Honor.
All right. This case is dismissed. Once it comes across, I'll sign off on it.
Thank you, Your Honor.
Thank you. Thank you, Mr. Fromm. Court calls case, People versus Richard Whittingham.
Raymond Bowman on behalf of Mr. Whittingham. Mr. Whittingham, would you identify yourself, please?
Hey, Your Honor, I'm Mr. Whittingham.
Okay, what are we doing on this case?
Mr. Whittingham had advised me that he would like to have this case sent over to the district court. I've advised him that he has a statutory right to a preliminary exam and what would have to be done at a preliminary exam. He understands all those features, and with that, he's asking the court to send this case over to the district court.
To the district or circuit court?
Circuit.
All right. Mr. Whittingham, do you understand that you're waiving your right to a preliminary examination?
I agree.
All right. And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
I agree.
And you understand you won't have that hearing and you'll proceed to circuit court for further resolution?
I agree.
I'll take that as a yes. Counsel?
The people also wait.
Preliminary examination having been waived, defendant is bound over to the court on both counts. Mr. Burkett, you acknowledge receipt of the information, waive its formal reading, and your client stands mute?
That is correct.
All right, defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 26, 2025 at 1:30 with Judge Krunke.
August 26, 2025, 1:30, Judge Krunke.
Thank you.
Thank you. Bond will continue with its conditions. Court does call the case People versus Anjanae Yancey.
Good. Hello, Your Honor. This is Anjanae Yancey.
Hello.
I don't know if you can see me.
Yes, we can see you.
Okay. Good afternoon, Your Honor. Gabriel Lacey for Miss Yancey.
I can't see you, Lacey. No, I'm kidding. All right. All right, what are we doing in this case?
Your Honor, I don't know if you would be willing to go into a quick breakout room with me and the prosecutor.
Okay, that really causes problems because then I got to move since you're on Zoom.
Oh, yeah. Okay. I hear what you're saying. Your
I mean,
Honor.
I can do it. If you think it's that important, I can do it.
I can put it on.
I'd have to pass it because I'd like to get one more case out of the way. But if you think it's necessary, I'll do it.
Okay, I don't mind you passing.
All right.
Thank you, Your Honor.
Pass this case. All right. Thank you. All right.
Good afternoon, Mr. Interpreter. Can you please unmute your device and raise your right hand to be sworn? Thank you, sir. Do you solemnly swear or affirm to interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Gujarati and from Gujarati into English in the manner now before the courts to help you God?
I do.
Thank you, sir.
All right. Court does call the case of the People versus Vishal Kumar Patel.
That's the people.
Could you interpret that, please, Mr. Interpreter?
Yes, I will. વિશાલ કુમાર, હું જયેશ પટેલ બોલું છું. જજ સાહેબે હમણાં જ કીધું કે આ તમારો જે કેસ છે એ જનતા અને તમારો બેની વચ્ચેનો છે.
Good afternoon, Your Honor. Nicholas Mott. Oh, I'm sorry. I thought he was done. Are you done, Mr. Interpreter?
Yes.
Okay. Nicholas Monrez on behalf of Mr. Vishal Kumar Patel, present and standing to my right.
અને વિશાલભાઈ, તમે તમારો જે વકીલ છે એમની જમણી બાજુ ઊભા છો.
May we approach, Your Honor?
You may.
Thank you.
Interpreter is still present. Go ahead, counsel.
Thank you, Your Honor. At this time, we're asking the court to set this matter for preliminary examination.
Could you say that, Mr. Interpreter, please?
Yeah. વિશાલભાઈ, અત્યારે આ સમયે ખાલી પૂર્વ તૈયારી માટેના તૈયારી માટે તમારા એટર્ની એમ કહે છે પૂર્વ તૈયારી માટે તૈયારી કરવાનો સમય આપો.
Preliminary examination will be set July 22nd, 2025 at 9 a.m. before Judge Barr.
એ પૂર્વ તૈયારી કરવાની જે એક્ઝામ છે એ જુલાઈની 22મી તારીખે જજ બારની સાથે રાખેલી છે, નક્કી કરેલી છે.
Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
બાન્ડ ચાલુ રહેશે. અત્યારે જે તમારું બોન્ડ છે એ ચાલુ રહેશે.
Thank you.
Thank you, Mr. Interpreter.
Have a nice weekend, Your Honor.
All right, you do the same.
Have a nice weekend.
Goes over that way. That goes over that. All right. That's the only one. All right. And is this my last?
You have the 3 o'clock in Zoom, and then you've got the recall on this case.
Okay, the 3 o'clock is, that's the comp. Let me do that one. Court does call the case of People versus Charles Hudson.
Good afternoon, Your Honor. Laura Willenbring on behalf of the people.
Good afternoon, Your Honor. Nicole Blank Becker on behalf of my client, Mr. Hudson. He is incarcerated. Is he there on Zoom as well, Your Honor?
Is he in back? Huh?
Is he in custody?
She says he's in custody.
He is in custody.
Really?
His name was never on any of the lists.
His name never, okay.
So.
All right. Folks, hold on. Let me pass the matter. We'll get him up here or on Zoom. They can have him on Zoom. I just need him here when I do this.
Okay.
All right. All right. Well, I'm going to go off the record, take my conference, come back. By that time, hopefully we'll have him on Zoom. All right, counsel. Thank you.
Thank you.
Thank you.
Court does call the case of the People State of Michigan versus Charles Hudson.
Laura Willenbring on behalf of the people.
Oh, you're muted, counsel.
Okay. Good afternoon, Your Honor, again. Nicole Blank Becker, sorry, Judge. It's been a long day. On behalf of my client, Mr. Charles Hudson, who is currently here now via Zoom. Thank you, Your Honor. We're ready to proceed.
All right. Sir, state your name, please.
Charles Hudson, sir.
All right. And council's requesting a forensic examination regarding competency. Is that correct?
Yes, Your Honor.
All right. And council, I apologize, but I just don't do them by stipulation.
No problem.
Okay. So I have signed the order, and then we'll set a competency hearing date for October 2nd, 2025, 9 a.m. We are, so the council's aware, that's pretty much that period in time. We are getting some back quickly for whatever the reason is. So if it does come back, we will notify the parties and set a hearing date in accord with statute.
Perfect. Thank you, Your Honor.
All right. Thank you.
Have a good holiday, everyone.
All right, everybody do the same.
Thank you. Judge, do you have the ability to put me in a breakout room with my client?
With him? Yes, I have that ability. Would you like us to do that?
That would be
I
great.
usually don't, but I will.
Because I'm the last one.
No,
Oh, no, there's another one.
because you're my favorite. That's why.
Of course I am. Thank you, Judge. I really appreciate
No,
it.
we'll make it happen.
Okay,
And
great.
we can
Thank
do
you.
that. All right.
Appreciate you.
There we go. Okay, court does call the case of People State of Michigan versus Yancey.
That is for the people.
Good afternoon again, Your Honor. Release.
Good afternoon, Your Honor. Andy.
All right. Okay, what we will do in this case, record to reflect we had a bench conference in this matter. Discovery is complete, correct, Ms. Lacy?
Yes, that is correct.
And would the people be able to have their witnesses available on the 22nd? All right. So I will set preliminary examination in this matter in person for July 22nd, 2025, 12 noon before me.
Thank you, Your Honor.
Thank you.